Mr. Pervis Payne before the court this morning. I will also just introduce my counsel.
Would you spell your name for the
I
record?
apologize.
It's all right.
It's Kelly. K-E-L-L-Y and N-R-Y. Mr. Payne is present in court via video link from the Department of Corrections. I also am honored to be joined with my counsel from the Innocence Project, Mr. Pervis, present on the screen, and Ms. Hacken. Hacken, P-P-I-N. Ms. Hacken will be addressing the court and examining witnesses. Also present from the Bill Bank Law Firm are Mr. Scott L-M-A-N.
Slow it down for me. So, say that name again, Scott.
Edelman. E-D-E-L-M-A-N. Mr. Judge Schwartz. Benedict R. And I neglected Mr. Scheck's name again. So. Also from the Bill Bank firm is Andrew Horton. Our Institute Horton. And I'm also present with me, my investigator, Ben. I think we're joining the council table to assist.
Any objection? Okay, Mr. Leonard, if you join council, please. Thank you. Payne State.
No, district attorney, S-E-E-D.
All right, are we ready to proceed? Henry? Did you want to make an opening statement?
Yes, Your
Go ahead.
Robert, again, it is my pleasure to be here today on behalf of my client, Pervis Payne, who has maintained innocence since 1987. He has consistently maintained that he is not the man responsible for the murders in this case. This morning, I would like to just give you a brief overview of how we believe the proceedings will go forward today. Mr. Jonathan Jackson has his own ideas. But I thought perhaps it would be good to narrow the issues early on so that you know what is being listed and what's not. One of the original issues in the case had to do with a number of items of bed clothing that was shown in the clerk's office December 20th, 2019. Weekend, I had an opportunity to review for the first time the crime scene video, which previously been told to me. I'm now convinced that those shoots did not come from the case and withdrawing a request to test those items. Nevertheless, there are a number of items that continue to exist in the criminal court closed property room, and we will proceed today with our request to test those items. There remains outstanding, even as we stand before you today, the question of where all of the evidence is. We have served subpoenas, we have done our best. We still haven't gotten clear answers. I'm hoping that we'll get some clarity today. But what we will be able to show you, Your Honor, is that there is evidence, testable evidence in custody of the property room in this building, Sewell and Poplar, that can be subjected to biological testing, new age, cutting edge DNA testing that did not exist previously. None of the items that we request to test have ever been subjected to DNA testing. And I don't believe that that matter is in dispute. That matter is conceded. The items that exist, to be able to establish the testimony from Mr. Keel, are here to retry this case. There are a lot of things I could say if I wanted to retry this case, but Your Honor is not allowed to do that. Not the purpose of the statute. Mr. Payne was found guilty. It exists because people have been found guilty, because jurors have heard evidence and rendered guilt. And yet those happened hundreds of times in this country, and we discovered through DNA testing that those individuals are innocent. So we're not going to retry the case today. We're not going to put on proof that maybe I would put on if we were able to get to it. What we will instead do is focus on the 4 requirements of the statute. The requirements of the statute are that there's a reasonable probability that petitioner would not be prosecuted if exculpatory results have been obtained from DNA analysis. And we know because of the Powers case that this court is required to presume that we would obtain a DNA profile from a third party on each piece of evidence that we seek to test. That's part of the analysis. You don't have to find it, you just have to presume it. And what's really important to understand is when you think about the fact that perhaps we get Kenneth Christopher's, the violent ex-husband's DNA on the knife, on the tampon, on other items of evidence that are in the criminal court property indisputably. There is no other explanation for him to be there except for the fact that he is responsible. Or he certainly is the one who has the motive. But we don't have to prove it will be any particular person. We don't have to prove Roy Jones or the Hall brothers who had debt where she had drug debt to. We don't have to prove it was the person that John Edward Williams saw running from the scene just as Mr. Payne was running into the building, even though we know that testimony exists in the record. We can presume that there will be a Pervis hit after the Powers decision, that we could put this evidence to code and that we can come back with a DNA profile of a serial killer. Now, I understand that the other side's argument is, well, DNA doesn't have a timestamp. But you can't explain a serial killer's DNA on a murder weapon in this case for any reason other than he's the person who committed the crime. So frankly, that argument is just silly. But Mr. Keel will be able to address that in some detail later on. And that I think is really the biggest argument in dispute. The second aspect of the statute is that the evidence is still in existence in such condition. Like I said, that's not disputed. The evidence was never tested previously. That's not disputed. And that the purpose of this request is to prove innocence and not presume. Your Honor, it is undisputed by the state that we can get DNA results back in 60 days. That is prior to the December 3rd execution date. We can get this done without delay. And we can get this done at no cost to taxpayers, thanks to the Innocence Project, who is willing to put the bill for the testimony. Quite simply, that point should not be in dispute as well. I would also just preview for Your Honor the fact that I believe the state of Tennessee is asking the court to commit error. It's inviting error. It's inviting the court to read into the statute legal principles that are not there and do not exist and are in fact inconsistent with the statute. It's asking the court to read in res judicata and waiver, even though it acknowledges that the case law is against them on that issue. And I would urge the court not to take that invitation. Finally, Your Honor, I would like to discuss our efforts to identify what exists and what doesn't exist. In Your Honor's interim order, advise the court at the next court date what efforts have been made. And although the burden is really more on the state because they have more access than we do, we went ahead and we issued subpoenas. We issued subpoenas to the following places. We issued a subpoena to the Tennessee Bureau of Investigation, to the West Tennessee Regional Crime Lab, to the Memphis property room downstairs on the lower level, and to Levon Her Hospital.
Okay, I'm sorry, to TBI, West Tennessee Crime Lab, property room here in this building. And who else, LeBonner?
Levon, their EMS department. Frankly, we didn't anticipate that they would have anything, but that was the only other place we could think of to service being on to bring up the support. We have not been able to find any
Okay,
idea.
so what was the result of the subpoenas?
The result of the subpoena, Your Honor, will be stipulated to that we have the file of the TBI, which I will submit to Your Honor as evidence. We have the case file.
Okay, so that's gonna be part of your proof today?
Yes, ma'am.
Okay, I got you.
Yes. We have not been able to locate any evidence other than the evidence that's in this book. We still have questions.
Okay.
We don't have chains of custody to explain that. We'll ask some questions
Okay.
about that. But the items that we are requesting, that we wish to conduct DNA testing on, are the knife, the tampon, the washcloth. And I should highlight the glasses, Your Honor, because the glasses did not become as relevant to us until we looked at the DA file last week. Because the glasses are not visible in the crime scene photographs that were introduced at trial.
I'm sorry, these are drinking glasses or eyeglasses? Okay.
When we looked at the DA's file last week, for the first time, we saw the reproduction of the eyeglasses. And they were just like this, folded at the head of the victim, covered in blood. Those did not come off the victim. And we can get wear and DNA, as Mr. Keel was on. Those glasses are highly relevant, and we did not realize the relevance until we saw those pictures of the DA's office last week. And while I'm discussing our efforts, Your Honor, it should be noted that we went to the Millington Police Department last fall and asked them for their files, their photographs. And we didn't get any photographs. We told everything's destroying the flood. We have a lieutenant here from Millington, has video, has negatives, has photographs. We don't have the subpoena power. Let's look at the case. All we can do is ask. Other
Okay, so
efforts?
I'm sorry, so I've read references to a flood. The flood was in the Millington Police Department.
A Millington flood that was supposedly destroyed everything. But here we go, we have some stuff that was, and he will testify and we'll see.
Okay.
We also requested in the fall a copy of the district attorney's file, including all of the photographs. We reported a $700 fee, $350 up front. I paid the $350 up front. We were told that we couldn't get a copy until January. We had a deadline in the Tennessee Supreme Court of December 30th. We had to file without benefit of the DA's file. And then late January, we were told, can't have a copy now because you post the execution date. And so now it is no longer public record. So the first time we were able to see the photographs that became so relevant about these glasses was last week. And those are our efforts. Your Honor. So in
Okay.
addition to the
So you
number
just saw the DA's file last week,
yes, ma'am. Photographs in the DA's.
the photographs. All right, I'm just trying to take this all in. I know this is just your opening statement. I'm sorry to keep interrupting. I'm just trying to follow everything. Okay.
In addition to the 9 tampon washcloth and glasses, we seek 2 items of clothing. I would note the children's clothing that is in evidence is not clothing worn by the victim at the time of the homicide. We still don't know. They didn't. I don't know what the clothing of the victim is.
The clothing of the children.
The female child and the adult victim.
Okay, the females, what they were wearing at the time of the attack.
Yes.
You don't have that.
I have a picture of it being collected. I don't have a chain of custody. I don't have any proof of it. And the same goes for Sharice Crystal. You know, there was a lot of testimony at trial that this was supposedly sexual assault or supposedly her clothing. We don't have a photograph of her clothing. Photographs that do have don't show her clothing, don't show evidence of a sexual assault, and we don't have anything to tell us what happened to her. If we could find it, we would want to test it. So I guess I'm making my record here. If it turns out somewhere down the road, we want to test it. There's also a stuffed animal. There are 2 sets of curtains. There is a blood-soaked rug. There's a paper bag. There's a blood-soaked cloth that's separate from the washcloth. And there are fingernail scrapings. Now, the fingernail scrapings is going to be an issue today, Your Honor. Your Honor ordered the state to respond to our response. And they said on page 7, they listed the items that we requested to be tested. And on page 14 of their response, They said all of the items existed except the vaginal swab. Now that we already knew was in dispute. But they affirmatively represented in a pleading to this court, after this court instructed them to make a search, that the fingernail scrapings exist. Yesterday, we received a response from the state that they no longer concede that all of the evidence exists. And I believe that the testimony today will be that no one can find the fingernail scrapings. Now, the fingernail scrapings were relevant at trial because, and you will see from some of our evidence today, there was an allegation, there was DNA that was not Ms. Christopher's, or there was biological material that was not Ms. Christopher's under her fingernails. Type A. State used that to argue Mr. Payne's guilt. But you know who else is type A? Kenneth Christopher. We could find out if it was Kenneth Christopher's DNA under her nails if we had it. There's no question about it. But we don't know. And I haven't seen chain of custody to explain it. So finally, Your Honor, after where I proceed, I plan to proceed with Your Honor's permission, is first to put into evidence some items that I believe are stipulated to the foundation. Then I will call Mr. Leonard to testify about the condition of certain items, the more relevant of the items that we saw. And then I will call Lieutenant Starks from the Norrington Police Department to have him discuss what his efforts have been. And then at that point, we'll call Mr. Keel, and he will be the bulk of our evidence today. Ms. Patkin will be doing that examination. I think since this is sort of like a bench trial, then it becomes the state's turn. And after that, in post for closing, if it's okay with Your Honor, Ms. Patkin and Mr. Porter will split our closing argument. Mr. Porter and the Milbank team have done a fantastic job of really pulling together the law, and he will argue on a legal basis. Ms. Patkin will argue about the DNA and the science of this. Quite frankly, she knows so much more about it than I do. And then finally, I believe Mr. Jones will have a chance to respond to Ms. Patkin if that is in the process.
Fine.
Thank you.
All right, thank you, Mr. Jones.
Your Honor, first, I'd just like to reply to the insinuation. My response was filed very quickly after they filed their petition. And my follow-up supplement that I filed yesterday after examining, completing the examination of the evidence. And we're talking about, my work product and how I went into my plan because the insinuation was floated out there that perhaps this evidence existed and I knew it existed, and then by the time I'm hearing it now suddenly doesn't exist and I'm withdrawing consent. I did not intend when I organized my argument, even though it is in the subject heading of that particular argument, that I said that aside from the swabs, everything else is in existence. I said that when I drafted and set out all my arguments that I was going to address completely. I set that out based on their filing petition. The requirement of filing petition is that the evidence does exist. So I presume that they were correct when they said the evidence exists. And over the weekend and Monday, when I went back and read everything yet another time and finished my examination of the evidence on Monday, I realized that there are lots of things that, contrary to their allegation, their petition does not exist today. I've subpoenaed everybody and asked everybody to be here that I could think of that has a possibility of having any of this evidence that's not here. And you'll hear from any of the prevention call that I've subpoenaed in state proofs. But the bottom line is there is no new evidence in this case. Every single item that they are seeking to have tested today existed when they sought testing in 2006 under the exact same statute. And they were going to argue Powers changed the law. I've argued Powers does not change the law, and that would be up to Your Honor to decide. But everything existed in 2006. Their opening statement, where they indicated that I've admitted in my response that the case law is against me, I made no such admission. On the issue of waiver, there's a there, and I indicated I was raising it in that context solely for preserving it on appeal. But the doctrine of law of the case, res judicata, collateral estoppel, all does apply to post-conviction cases, especially when the Supreme Court rules recessive. So submit that the opportunity and the issue of whether evidence from the crime scene or the evidence from Mr. Payne's clothing in various places that was collected, whether or not that meets the criteria that they're seeking today for testing of DNA, has previously been determined, been considered by the Judge Wyman who tried the case, and the Court of Appeals reviewed his decision with permission to appeal denied by the Supreme Court.
Wait a minute. Say that last part again, Judge Wyman?
The 2006 post-conviction DNA petition, their first petition,
Yes,
so they sought testing of DNA testing of crime scene evidence.
yes.
That hearing, to the extent it's a hearing, just like we're doing today, that was before Judge Wyman.
That's not accurate. Judge, for whatever reason, what happened in this case, as you know, is Judge Wyman handled the jury trial. He handled, after it went through the appellate process, he handled the post-conviction.
Okay.
And it went through the appeals. And then when the petition for DNA was filed, for whatever reason, it went to Division 3.
I wasn't aware of that.
Yes.
Regardless.
I was on the bench in 2006.
Okay.
For whatever reason, it went across the hall, and Judge Colton ruled on that. Then there was another petition filed for error of quorum notice. Judge Carter heard that.
Okay.
Then some other petitions were filed, constitutional issues, which came back over to me.
Okay.
So
I was
strangely, it went to 3 for a couple of things, then came back over to me, and now it's back in front of me for the first opportunity, Mr. Payne, to have this issue heard by me.
okay.
So it was not heard by Judge Wyman. It was heard across the hall.
Okay. I was unaware. I apologize.
That's not accurate.
Regardless, it was heard by a judge from the court, and that was appealed and reviewed by the Court of Appeals, and permission to appeal was denied by the Supreme Court. So, other than that, the state submits that the first factor and the fourth factor cannot be met. The fourth factor, in particular, the purpose for filing this was to demonstrate actual innocence as opposed for delay. And I think we're going to look at the timeline of this case. That will be out in the homicide of Sharice Christopher and Lacey Christopher. The assault against Nicholas Christopher occurred June 27, 1987. The trial was 1988. The Tennessee Supreme Court issued its decision in 1990. The U.S. Supreme Court issued its decision in 1991. Federal court heard for the first time in the life of this case a mention of DNA testing in 2000. The first DNA petition request was filed in 2006. Powers came out in 2011. Counsel examined the state property room evidence in December of 2019. The Supreme Court set the execution date on February 24th, the execution date being for December the 3rd. And not until 4 months and 1 week prior to that execution date, that they filed this petition, their second, seeking to DNA test evidence for the crime. Thank you.
Thank you, Mr. Jones. All right, call your witness.
Thank you, Your Honor. I've prepared.
To our reporter, please, and to me. Let's, I make a copy of that. Did you get it?
I apologize.
It's all right.
I've got 2 printers with me that it's out.
We got it.
For the first item of evidence, I'd like to introduce.
Would you give us 1 second? He's gonna make, we got it.
Thank you, Your Honor. Your Honor, exhibit one and two, exhibit number one is court order of December 20th, 2019 that permitted us to use the evidence in court. And I would like to submit that to exhibit number one.
No, Your Honor.
Okay, we have that. Actually, that was signed by Judge Crack.
Yes, Your Honor, it was.
I wasn't here.
By intercession, or whatever that fancy word is.
Interchange.
Interesting. Your Honor, is that okay for me to ask for this?
Yes, yes. Okay, we've got the order's been marked exhibit one. Okay. Submitted.
Exhibit number two, Your Honor,
Exhibit number two is the original exhibit list from the criminal court trial in this case, which I thought would be of use to the court so that you could observe what had already been introduced to the evidence and accepted at the trial. And that's exhibit number two, which I believe also.
Is that from the clerk's record or from the property?
Clerk.
Okay.
Okay, so that's exhibit list from original jury trial dated February 10, 1988. Submitted.
Thank you, Your Honor. Your Honor, if I could be allowed one more point of privilege just to make a record, that's, there's no suggestion that someone else might be looking at this. And as the court knows, as everyone knows, we're under COVID-19, but it should also be noted that my office has been closed since March 15th of this year. It remains closed.
Okay.
And in fact, we're not going to be allowed back in the office at all for any reason for 2 weeks after we come back from Memphis. So when we get to issues of alleged delay and such, I think it's important to put the COVID-19 incident on record.
Thank you.
Thank you. Your Honor, I call Ben Leonard.
Mr. Leonard? Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Right. State where your office is located, the record.
Thank you, Your Honor. Our office is located in Nashville, Tennessee. Question of protocol. Do you prefer from the counsel to examine witnesses from the table or from over there?
Doesn't matter.
A little easier for me to go over there. Okay. Mr. Leonard, could you state your name for the record, please?
Payne, Leonard, B-E-N-L-E-O-N-A-R-D.
Mr. Leonard, how are you employed?
I'm an investigator for Federal Defense Office, Nashville, Middle District of Tennessee.
Did you get a fancy title and promotion in position?
I did.
Mr. Leonard, could you just briefly describe for the board your educational background?
I attended Middle Tennessee State University. I received an associate's degree in law enforcement. Later, I received a bachelor's degree in criminal justice with a minor in psychology and sociology.
After graduating from MTSU, did you begin your work as a criminal defense investigator?
I did.
And where did you start?
The state public defender's office in Nashville.
And from there, where did you go?
From there, I stayed there for 3 years, and then I went to Inquisitor, worked for Ron Rice, investigator. We have 3 locations: Memphis, Nashville, and Knoxville.
After working for Mr. Black, did you obtain another position in criminal defense investigation?
Yes, there I relocated to Texas, like, I worked for Francis and Associates, another investigative firm, where we investigated capital cases, misconviction and trial.
After your time with Ms. Francis, did you then join the federal public defender system?
I did.
And what year was that?
That was 2000.
And where were you first assigned?
I was signed in Eastern Washington. I moved federal defender's office across state line from Washington and Idaho.
And then in about 2007, is that when you came to Nashville?
That's correct.
During your time as a criminal defense investigator working out of the Nashville Federal Public Defender's Office, have you had an opportunity to visit the criminal court clerk's property room here at 201 Poplar to review evidence?
Yes,
Few or many times?
many times.
When you have viewed evidence in the criminal court clerk's property room, is there a process that you go through each and every time?
Yes.
And what is that process for?
The process is I contact them, relating information about the case, the evidence I want to review. Give them a date. Pull up, or after that, pull up.
Okay, proceed, please.
All right, I would, then I would come and go to the property room, and they would bring the evidence out. And after they bring all the evidence out, I would start reviewing the evidence one piece at a time. Although before we start reviewing the evidence, they would have latex gloves and paper for you to place the items on, the evidence on, so that they can contaminate.
And as you look through the evidence in the criminal court clerk's property room, can you describe the process of getting the evidence out of the box and reviewing it? How does that work?
Well, when they bring it all out, some evidence is in boxes, some is in paper bags, and other containers. I would open one bag at a time or one box at a time, take all the evidence out and review it. And then after reviewing that one box or that one bag, all the evidence is put back in that same bag before I move to the next bag or box.
And I want to direct your attention to December of 2019. Did I ask you to come to 201 Poplar to the criminal court clerk's property room, which at that time I believe was on the fourth floor?
Yes.
It's now moved upstairs.
Sure.
But did we come to the fourth floor to review evidence in the court's property room?
Yes, ma'am.
Were you required to obtain a court order to review evidence?
Yes.
Had you ever been required to obtain a court order to review evidence before?
No.
Did you obtain the order?
Yes.
And did you present that order to the clerk at the property room?
Yes, ma'am.
And are you familiar with the individuals who work at the property room?
I am.
And could you say for the record those individuals who we came into contact with that day?
Townsend is his last name. And then you have Claude Johnson, Steve, I believe the young lady named Kristen. I think all 4 were there that day.
Who else?
I'm sorry. Want some environments, Kelly, if I could. I want to clarify about the rule of witnesses. I'll make sure that we are.
We did not go to. So those individuals were there, some of them the whole time and some of them not, is that correct?
That's good.
Who else was present with you that day?
You, Kelly Henry, and another attorney, first attorney, Lee Booby,
Can you spell Ms. Wilson's name for both of them?
Lee is spelled Goolsby.
And D is just DEE.
Yes.
The criminal court clerk's property room produce the Pervis Payne evidence pursuant to the court order for us to review.
They did.
Did you follow this process of using paper and gloves that you described in the court before to review the evidence in this case?
Yes.
Did anyone other than yourself handle the evidence?
No.
In the schools, we took photographs.
Yes.
Mr. Leonard, you filed a declaration in this case earlier in July, is that correct? And you had an opportunity to review that declaration again. And attached to that declaration were a good many photographs of the evidence that we observed in the criminal court clerk's property, correct?
Yes.
And were those photographs a fair and accurate depiction of the evidence that we saw and the condition in which it was in for property room in December of 2019?
Yes.
I'm not going to go through each and every one of these exhibits. Those are in the record, attached to the motion, but there's a few that I want to direct your attention to. Before I get to the ones I want to draw your attention to, just to make the record clear, we've already conceded that the bed sheets comforter didn't come from this particular case. At the time, when we were reviewing the evidence, were we provided with a bag that had bed sheets and a comforter and a pillow inside?
Yes.
And did we seek clarification that that evidence had in fact come from Pervis Payne's case?
Yes.
And believing that to be the case, we took many photographs, correct?
That's correct.
And those photographs are attached to our plea. And we have since had an opportunity now to review the crime scene tape in our case, as well as the DA's file, as well as the file in Robert James' case. Is that correct?
That's correct.
And you were present with me when we did that.
Yes.
And that was last week.
Yes.
And we now concluded that those sheets came from the Robert James.
That's correct.
We're not going to talk about those, but we're an issue, but there are a few photographs and items that I do want to discuss today. Did you want to say? I'm so used to that report. May I approach the witness?
No.
Thank you. So I'm going to hand you an item marked as Petitioner's Exhibit number 3. Mr. Leonard, I asked you about going to the District Attorney General's office to review the file. Were there photographs in that file that you had never seen before?
They were.
Is Exhibit number 3 one of the photographs that you've never seen before?
Yes.
And what is in that photograph?
There was a picture of the victim's hand along with the fence wound on her finger. A broken nail on the little finger.
Your Honor, it's submission of Petitioner's Exhibit number 3.
So we don't have any better photos than this.
That's what I got.
Okay, exhibit 3 is photo of a hand.
I should say Mr. Jones may have a better copy. That's the quality of the copy that we will provide.
And Your Honor, I would object, I've got, I was subpoenaed to bring all the photos and files on my entire file. I do have the photos, but this was back in the day when it was negative, and I print them out, not digital, we do today. Unless it was indicated on the back, I would object to his testimony about whose hand it is.
Well, it's not a child's.
But proceed.
Move on.
Okay, thank you. Leonard, I'll show you now what's been marked as Petitioner's Exhibit 4.
Right.
And what is Petitioner's Exhibit number 4?
It's a picture of a hand front and back.
And have you had an opportunity to review the file produced to us by the West Tennessee Regional Forensics and Community Autopsy? Ms. Christopher?
Yes,
Do you recognize your exhibit number 4 as a diagram of Sharice Christopher's hand as depicted in that autopsy report?
yes.
You are in the mission of petitioner.
Exhibit 4, diagram of the hand with wounds.
Listening to the
Get back to the evidence
that's
that we reviewed.
what
You have to use petitioner's exhibit number 5.
Yes,
And is that in fact a photo of the evidence sheet on the outside of the packet containing the knife?
yes,
You are in the mission of petitioner's exhibit number 5.
Exhibit 5 is moved into evidence.
Showing you now petitioner's exhibit number 6. Do you recognize that to be a photograph of the outside of the packaging in which the knife was contained?
that's right.
Is that true accurate depiction of the condition of the packaging prior to opening it?
Yes,
You're under the mission of petitioner's exhibit.
All right, admitted into evidence.
Showing you now the petitioner's exhibit number 7, which is a photograph of the inside of the bag. You recognize that?
yes, I do.
What is inside of that?
That bag is the 8-inch knife that was taken from 4516.
Did you remove the knife from the sack?
I did not.
Did I in fact instruct you not to remove it?
That's correct.
Does that photograph fairly accurately depict the condition of the knife as we observed it in December of 2018? You're under the mission of petitioner's exhibit number 7.
Moved into evidence.
Moving back now to some photographs we saw in the district attorney's file. I'm handing you petitioner's exhibit number 8. Do you recognize that photo?
Yes,
Is that a photo of the knife as it was depicted in the district attorney's file when we reviewed this last week?
yes, it is.
You're under the admission of petitioner's number 8.
All right, moved into evidence.
For petitioners 9, 10, and 11 will be introduced through Mr. Keel, so I'm going to skip this one. We're going now to exhibit number 12. Mr. Leonard, do you recognize exhibit number 12 as the outside of the packaging that contained the washcloth in the case? Is that a fair and accurate depiction of the packaging that contained the washcloth?
Yes, it is.
You're under the mission of petitioner's number 12.
Moved into evidence.
Showing you now petitioner's exhibit number 13. Is that a photograph of the washcloth that was contained inside the packaging? Number 12, exhibit 12.
Yes, it is.
Is that a fair and accurate depiction of the way the washcloth appeared when we viewed it in December of 2018?
Yes, it is.
That hole, there looks like there's a hole cut out,
Yes,
probably by the lab.
Right.
But that hole was already there.
correct.
You're under the admission of petitioner's 13.
All right, moved into evidence.
That's all the questions I have.
Mr. Jones?
Right, Mr. Leonard, you testified about all the items examined and proctored in December of 2019. And in your declaration, I believe was titled, attaches appendix to the petition for post-conviction DNA analysis. You indicated you follow standard protocol to protect against contamination of the evidence. Purchased a new block of 200 latex glove, which you did not open until just before the inspection of evidence began. And you said I also placed a fresh piece of brown paper across the table where the evidence was examined. And you also said I changed the paper after examining any item of evidence which contained biological material. Right?
Yes, sir.
All right. And do you know, prior to you examining this evidence in December of 2019, who else has examined that evidence?
No, I can't.
In fact, some of that, most of that evidence was introduced in Payne's trial. Is that correct?
Yes, sir.
And do you have any idea how any of that evidence, either the evidence that was introduced at trial or the evidence that was not introduced at trial, I believe you refer that to the property room's designation of residual evidence or residue evidence.
Mhm.
Do you have any idea how any of that evidence was handled by anybody, prosecution or defense attorneys prior to or after trial?
I do not.
Any idea how it was handled by the deputies in court when it was introduced as evidence and handed to the witness?
I do not.
Any idea how the clerk handled that evidence after it was introduced in evidence from night to night as the clerk took custody of it and brought it back for trial the next day?
I do not.
Do you have any idea of how that evidence was handled by any of Mr. Payne's subsequent counsel, not your office, but prior to your office representing him, when it was examined in the property?
I do not.
So you can't testify as whether or not this evidence has been subject to cross-contamination of DNA after the crime.
Your Honor, I object, Mr. Leonard has not been offered as an expert in contamination. That's what Mr. Hill.
I think he can answer these questions.
Also regarding whether or not you saw certain files. First of all, when you asked to see my file, I invited you to see it, correct?
That's correct.
You and Ms. Henry, and you had access to the entire file.
That's correct.
Do you know whether or not the attorneys who represented Mr. Payne in his 2006 DNA petition, what photographs and evidence they looked at the DA's file?
Your Honor, I object as it calls to ask Mr. Leonard to speculate. He wasn't on the case.
If he knows, he knows. If he doesn't,
All right, you can answer the question.
do you know what in the DA's file, including photographs or property that the post-conviction attorneys who represented Mr. Payne examined?
No.
What about the trial attorney? Do you know that there's a notice of discovery in the clerk's jacket that indicates that the defense attorney, Mr. Garz, did examine the photographs and evidence in this case prior to the trial?
Your Honor, I'm going to object to see that's not.
Oh, these are points that he can bring out. I'll overrule that.
Repeat the question.
Do you know whether or not, or are you aware that in the clerk's jacket in this case, trial proceedings, that there is a notice of discovery that indicates the defense attorney who represented Mr. Payne at trial, Jim Garz, reviewed the photographs in this case and reviewed the evidence in this case prior to the trial?
I'm not aware of it.
And so you don't know whether or what procedures he used to examine the evidence when he did so. Is that correct?
That's correct.
And you said the property room had available to you, you say you brought your own glove, right?
I bought my own gloves.
Okay.
But they also have,
Okay. And you also had paper to put down for you to examine.
that's correct.
Okay. Do you know whether or not they had gloves and paper to put down in 2006?
I do not know.
Do you know whether they had it in 1987 or 88?
No, I do not.
That's all I have, Your Honor.
Oh,
Your Honor, I got to have myself. There are 6 words in it. I should have tried to use.
okay, go ahead. Go ahead.
It's moving so quickly. I forgot. It's really, again, directing your attention back to the examination and criminal court purpose property agreement. And I apologize, I only have one copy. This is exhibit number 14. Do you recognize exhibit number 14 as the evidence sheet for
Yes,
the package containing tampons?
that's correct.
Here I move the mission of exhibit number 14.
All right, can you move into evidence?
Showing you now petitioner's exhibit number 15. Do you recognize that as the outside of the packaging of that contains tampon?
Yes, that's correct.
And is that a fair and accurate depiction of the packaging prior to the opening of the packaging?
Yes,
You're under the mission of petitioner's 15.
So 15, okay, move into evidence.
Showing you now petitioner's 16. Is that a picture of the tampon that is contained inside that package that we just looked at?
yes, it is.
Is that a fair and accurate depiction of the condition of tampon at the time we reviewed it in December 2018?
Yes,
Your Honor, I move the mission of petitioner 16.
Move into evidence.
Bring back to the glasses we observed in the DA's file. I'm showing you petitioner's number 17. Do you recognize that as a photograph that we observed in the district attorney's file?
yes,
Have you seen that photograph?
uh,
Your Honor, I move the mission of petitioner's number 17.
Exhibit 17, move into evidence.
Showing you now petitioner's number 18. Why is petitioner's number 18?
picture of the glasses.
Yes.
Right.
And is that a fair and accurate depiction of glasses as we observed them in the criminal court for the property room in December of 2019?
That's correct.
Thank you, Jackie. Thank you, Jackie. Yes.
Oh, I'm sorry. What's that? Coach check?
Yeah.
No.
It's, we have the jacket.
Which one? The original jacket?
Yeah, what jacket do you need?
I'll just ask.
Okay.
On cross-examination, you were asked your knowledge about what's written on the outside of the jacket. Have you seen jackets before in Shelby County?
Yes,
And that refers to the master case file.
that's correct.
Number of items are often written,
Correct.
often in shorthand.
Yes,
If a document, the jacket says that the defense attorney reviewed photographs, do you have any way of knowing which photographs the defense attorney reviewed?
I do not.
Or any way of identifying which evidence the defense attorney reviewed?
I do not.
And have you in fact worked on cases in Shelby County where the defense attorney reviewed some evidence and then it turned out we found other evidence? Like,
Yes,
that's all the questions I have.
Okay.
Just really to clarify, and I'm going ahead, I was anticipating on moving this in, but since we brought up, I did not ask Mr. Lynn, I did not ask you, sir, whether or not you noticed notation from the court jacket. I was referring to an item titled additional memorandum of discovery that was introduced, or that was contained in the jacket. I would pass this forward and ask you seen this. Have you seen that document before? No, I didn't intend to introduce it. I do wish to introduce it, but I don't have copies.
We can make
Sure.
copies.
I-
How many
Maybe
copies?
just go to the next time.
Yeah, go ahead.
I would just need a copy for the next time.
No objection, Your Honor. Your Honor, I anticipate our exhibit will stop at 23. Our emergency.
Oh, okay.
I don't have an objection to, I don't know if that'd be proper form for the record, but I don't, it doesn't matter to me what number that
Okay.
is.
All right, what is this called?
This is a notice of additional discovery, I believe. Let me check. Additional memorandum of discovery. It's contained in one of the jackets of the clerk's jacket in the clerk's possession. So
Let me
it's
take,
technically already in the.
let me see it. Let me see.
I think
Where
it's
is it?
the only copy of it.
Oh, okay. Um, We've run out of right size paper back here. We don't have a secretary.
I'll be happy to make copies later with the court.
Right.
You know, and move on.
Okay, so it's additional memorandum of discovery. That's exhibit 24. Okay. All right. Get this month. Okay. All right, anything
Yes,
further?
that's all I have, Your Honor.
Thank you very much.
All right. Deputy, let's do this. Let's take a recess. You can step down. Thank you very much. Let's stand in recess for 5 to 10 minutes. Got an issue with some of the audio for somebody. Let's stand in recess. We'll come back and proceed with the hearing.
We'll stand in recess.
Your Honor, if I could borrow that to the court, make copies. I can go to
Sure.
my board deal.
Yeah, they should do
Hey, do you think if we turned her volume up? Because isn't it this one?
Everybody else.
I think
Rebecca, second.
All right.
As a matter of housekeeping, exhibit 24 that I introduced was actually a truncated copy, and we have the full copy. I like to substitute for that exhibit.
Can only do this on long paper, I guess.
I'm sorry?
Only do it on long paper.
Yes, because that contains the actual entirety. It was reflected in the clerk's chair.
All right, so that's exhibit. Okay. So we're echoing, Mr. Ford, echoing, I'm echoing. Thank you. That's it. All right. Ms. Henry?
Your Honor, next we have just a few other items of evidence that we get information stipulated to.
Okay.
Petitioner's exhibit 19 is a compilation of crime scene diagrams.
All right, exhibit 19, crime scene diagrams moved into evidence.
Exhibit number 20 is a complete copy of, it is not a person stapled, so I'm going to give you the folder, of the West Tennessee Regional Crime Lab file.
Okay.
And on the cover of it is the subpoena served to them, so you can see what it is.
Right, great. Okay. Where is it marked? Is it inside? Yeah, okay, inside. All right, West Tennessee Regional Crime Lab file, exhibit 20.
Exhibit 21, Your Honor, is a complete copy of the TBI file that's produced pursuant to subpoena.
Okay. Exhibit 21, TBI file.
And those are all the exhibits I have of stipulation for, and we'll call Lieutenant Stokes from the Illinois District.
Okay, Lieutenant Stokes.
Please stand, circle your right hand, one, two.
You solemnly swear or affirm to the truth, the whole truth, nothing but the truth, so help you God.
I did.
See up here, please.
Morning, Mr. Stokes, or Lieutenant Stokes. Could you state your name for the record and spell your first and last name?
My name is Christopher Stokes, CHRISTOPHERSTOKS.
And what is your position, sir?
I'm a lieutenant in the Middle Tennessee Police Department.
And how long have you held that position?
The lieutenant's position I've held about 3 years.
Lieutenant Stokes, did you investigate the Pervis Payne case in 1987?
No, ma'am, I did not.
Are you here pursuant to your subpoena that I possibly served on the Wilmington Police Department to bring evidence, photographs, videos, basically anything in your possession regarding the homicide issues, Christopher Lacey, Christopher Nicholas, and assault on Nicholas?
Yes, ma'am.
And did you do that?
Yes, ma'am.
And prior to court, did we have an opportunity to have a brief discussion?
We did.
And did you at that time provide me with a copy of all of the documentary evidence that you have?
Yes. Yes, I did.
And so I now have that next.
Yes, ma'am.
And you also have with you in an envelope some original photographs, is that correct?
I do have photographs, a VCR tape, and negatives.
Is the VCR tape that is the crime scene video that you previously provided to Mr. Jones last week?
Yes.
And did you copy the VHS tape frame for frame onto the DVD?
I did.
And so the DVD that was provided to him is accurate. I would like to direct your attention to the empty envelope inside of that.
Yes.
What you got? Can you describe that for the court, please?
It's a property envelope, just says homicide 4516 Biloxi number.
And 4516 Biloxi number 4 is the address of the crime scene in this case?
Yes.
And is the envelope open?
Yes, it is.
Is there anything inside it?
There is none.
Is there any writing on the outside as to initials, a detective's name, and
There's not.
I'm not clear on the court's preference. I'd like to introduce the envelope into evidence, but I know it's the original copy. And file.
Fine with me.
Here we have the exhibit marked, please, thank you.
Okay, so I guess that would be exhibit 25. All right, let's see. 19 envelope. Crime scene. Oh, it's homicide. Is that, sorry, is that 45?
But yes, I believe 4516.
Okay.
Below.
Number that is. Okay, 4516, blood scene number 4. Thank
Where was the empty envelope located?
It was in the envelope with the photographs and the VCR tape.
And where was that located?
It was in a storage shed.
And where was the storage shed?
It was on the police department parking lot.
Where is the first one?
It is in Middleton, Tennessee.
And what is the address?
7950 Memphis Avenue, Middleton, Tennessee, 3805.
you. Okay, I'm sorry, I missed some of that. It's in the storage shed.
It was in a storage shed on the property of the Middleton.
And just one more time, maybe a little bit slower. You and I both talked to you.
You do.
Can you tell us the current address of the Wilmington Police Department?
7950 Memphis Avenue, and that's Middleton, Tennessee, 3053.
Did the Wilmington Police Department was the Wilmington Police Department previously located on Maiden Road in Wilmington, Tennessee?
It was.
So when we look through old reports in this case, if we see the Maiden Road address, we'll know that's the police department.
That's correct. It was 4836 Navy Road.
There's another envelope, another brown envelope contained inside the larger manila envelope that you have. Can you pull that out and tell us what's inside?
This is labeled negatives 62787 Pervis Payne, and it says arresting officer S.D. Wilson. And it contains 5 35 millimeter film cases. They're listed as Payne on the top with the date 6/27 of 87.
Is there any way to determine whether those are black and white negatives versus color negatives?
I wouldn't know.
I'd like to have that exhibit marked as Commissioner's number 26.
Okay. So it's an envelope with negatives in it related to purpose.
Where are you, Commissioner, Commissioner's exhibit 26?
It's much in fact.
Thank you, Your Honor. You brought a lot of different photographs with you today. And Your Honor, I have had an opportunity to review those photographs and do not feel that it would aid the court to go through each of the photographs. One by one. I would, however, make a request that we be permitted to have the negatives examined. There was an issue in this case where the roll of colored film allegedly was ever put in the camera. For a lot of photographs that were taken in the case, I'd really like to see there's no roll of colored film there.
That's just what relevant.
Okay, I'm sorry. These negatives you're talking about,
Yes, ma'am.
you'd like to have them developed? Is that what you're saying?
Or at least examined to determine if there are any colored photographs.
Oh, that was part of your request.
Yes, ma'am.
Okay, but this is a request for DNA.
So, yeah, just to see if there's anything in there that would be relevant to our request for discovering more evidence.
Well, I mean, I'm curious also to see what's in there, but I don't know that's covered by the statute.
Well, perhaps we can table that for later and I can pursue research.
Okay.
Thank you, Madam. But as I said, I don't feel that there's a need to have a team start spin through all the photographs. I believe I've seen all those photographs before.
Okay.
I have a PA spot.
All right.
So I'm not going to my examination, Mr. Stone.
Okay, Go ahead.
Mr. Stokes, you were the person that Millington sent to respond to us, is that correct?
That's correct.
Other than the documentary evidence that you provided and the photographs, negatives, and video, does the Millington Police Department have in its possession any other evidence related to the Christopher homicide?
I didn't,
And how do you know?
because I searched for all evidence from the 1980s. There was none. I also searched for evidence under Pervis, Payne, and there was none in our property. There's also in your file a list of evidence that was brought to the criminal court pursuant to this case.
And you did in person search?
Yes.
Thank you, goes well.
All right, Lieutenant Stokes. When were you first employed or hired by the Millington Police Department?
I was hired full-time in 1987. I started part-time in 1994.
Okay. So you were working with the department in 87?
I was not.
Okay. So I thought I heard you say you were in 87. When did you first start with? the
Full 1997.
97, I apologize. Okay. So you didn't have anything to do with this investigation?
I did not.
Do you know, or are you aware of what methods of collecting the evidence that the Millington Police Department used in collecting the evidence from the crime scene?
I do not.
Go ahead.
Thank you very much.
Thank you very much, Lieutenant. Come in.
Trying to raise the number of this.
Call your next witness.
Next, I'm going to turn it over to Ms. Vanessa Hopkins, who will proceed with Mr. Field's testimony.
All righty. Ms. Pumpkin?
Thank you. I just want to briefly make sure that the audio is working okay, and if it's possible to enable this share so that Lauren can share her screen, that would be great.
Okay, Corey's going to help. The audio is not coming through great.
Thank you, Judge.
Can we mute everybody that's not, what do you say? Go ahead.
I think I'll need to be the presenter in order to share my screen.
Okay, thank you, Barry. I think we had a little trouble hearing earlier. I believe that Kelly put our appearances on the record. Vanessa Hopkins.
We don't have you here. Can just, you can just give us a second here. We're going to try to get you clearly.
Yes.
Yeah, I'm gonna move out of the way, let Mr. Ford try to work his magic.
Ms. Potkin, could you give me a test countdown?
Yes. Can you hear me?
Yes, ma'am. All right, one more time.
Okay. One question I'll ask as I'm doing this is, should we test Mr. Keel as well?
Certainly.
Good morning, everyone. I can hear you loud and clear.
Very good. I'm going to turn our microphone off and let you all roll. Can you, Mr. Can you stay here, okay?
Yes,
Very good.
Fantastic. So my name is Vanessa Potkin, and I believe Ms. Henry put our appearances on the record. I'm with the Innocence Project and appearing here along with Barry Scheck, the co-founder of the Innocence Project, who's co-counsel for Mr. Payne, along with myself. The next witness that we would like to call is Charles Allen Keel. Does Mr. Keel need to be sworn in before I begin?
Mr. Peel, hear me?
Yes, ma'am.
Would you raise your right hand, please? You solemnly swear the answers you're about to give will be the truth, the whole truth, and for the truth so help you God.
Yes.
All right, thank you. You may proceed.
Thank you, Judge. Good morning, Mr. Keel, or bordering afternoon. Could you please introduce yourself to the court?
I'm Alan Keel.
And where are you employed?
I am at the Forensic Analytical Crime Laboratory in Hayward, California.
And what is Forensic Analytical Crime Laboratory?
Forensic Analytical is a private, essentially full-service crime laboratory. We do criminal investigations for both the state and private counsel. We have forensic DNA analysis services. We have firearms and crime scene reconstruction. We have a pathologist on staff. We essentially are a full-service laboratory with the exception of fingerprint comparison capabilities.
And what's your position at Forensic Analytical?
I am the supervisor of the forensic biology and DNA analysis unit. I am also the DNA technical lead analyst for the unit, and I am also a bench analyst myself.
So can you explain for the court what the difference is then between forensic biology and DNA analysis?
Yes, forensic biology encompasses that aspect of an investigation of physical evidence for human body fluids that is concerned with the location and the characterization of the biology as to whether it's blood, semen, saliva, just what the nature of the biology might be from which we might recover DNA for DNA profiling. So it's essentially the first half of the work. And then forensic DNA testing would be the extraction and DNA profiling of DNA from that biology of interest, and then comparing that profile to persons of interest.
And I just am making sure, Barry, are we still good with the sound? I believe we are, but I just wanted to make sure because I see it coming in the screen. Give me a signal if we're not. So can you talk about some of your responsibilities as supervisor of the forensic biology and DNA unit?
Yes, essentially that means that I coordinate the distribution of casework and other responsibilities between the three analysts in the unit, being myself and two other analysts. So that's my primary duty as supervisor.
And you also mentioned that you're DNA technical leader. Could you explain what that is?
Yes, the DNA technical lead position is a position that is required by our accreditors and by the the FBI quality assurance standards, this person is responsible for the day-to-day activities of the DNA analysis unit and those procedures that are accredited, and in the administration and the actual conducting of those procedures during the day-to-day testing of physical evidence.
So is forensic analytical accredited, and do you comply with the, or meet rather, the FBI quality assurance standards for DNA laboratories?
Yes, our DNA unit is fully accredited by ANAB, just like every other government and other private laboratories that wish to participate in CODIS. So yes, we are fully accredited.
And you mentioned that you also perform casework. About how much of your time is spent examining evidence from crime scenes and conducting DNA testing?
It varies based on our caseload, but my time at the bench examining physical evidence is, I would say, 20 to 30% of my time.
And how long have you been employed at Forensic Analytical?
Since 2011.
In total, how long have you been working as a forensic analyst, examining biology and performing DNA testing?
I began my career with the North Louisiana Crime Laboratory in Shreveport, Louisiana in 1982. I worked there for 2 years before accepting a position with the Oakland, California Police Department, where I worked there for about 9.5 years. And then I have also worked briefly with the Tulsa, Oklahoma Police Departments. And then I worked for about 3 years with the San Francisco, California Police Department Crime Laboratory before going into private practice in 1999.
So from 1982 to 1999, you worked for law enforcement crime laboratory.
Yes, there was a very brief period in which I worked for the Caddo Parish Medical Examiner's Office as an investigator in Shreveport, Louisiana. But primarily, I have about 15 years with law enforcement, yes.
And you mentioned that you started off at the Northern Louisiana Crime Laboratory. What work were you doing there? You said that in the early 80s, so this is pre-DNA. So what type of examinations were you doing?
Yes, this was before the advent of DNA technology. In Shreveport, I was trained how to examine physical evidence, what to look for, how to find body fluids of interest on various substrates, various items of evidence, and how to capture that biology into a form that it could then be tested using the conventional serological and ABO blood grouping methods that we had at our disposal at that particular time. So those first 2 years were essentially training years, learning how to use the techniques that analysts in crime laboratories use. And that was primarily under the tutelage of Dr. Pat Voitkevitz.
And when you say you were in training to learn the tools that forensic analysts use, in the serology days and the DNA days, in general, what is the question when evidence is submitted to a lab? What question are you trying to answer through an attempt to identify biology and perform this type of testing?
The fundamental question is there biology present that might be probative in helping determine what happened at a particular crime scene, and in determining who may or may not be a potential source of that biology.
And after the Northern Criminalistics Lab, you said you worked for almost a decade at the Oakland Police Department Crime Lab.
Yes, I worked for the Oakland Police Department in the laboratory from 1984 to 1993. And during that time, PCR-based DNA analysis techniques were developed. And so I implemented DNA analysis capabilities in the Oakland, California Police Department as it became available commercially. And that was about 1990, 1991.
And after you helped implement DNA testing in the Oakland Police Department Crime Laboratory, moved on eventually to the Tulsa, Oklahoma Police Crime Lab.
Yes, I worked very briefly in Tulsa for the police department. And essentially what I did there was to implement forensic DNA analysis capabilities in that laboratory as well before I accepted the position with the San Francisco Police Department in 1996.
In what year?
In 1996.
Okay. So you didn't stay in Tulsa long. Why did you go to Oakland Police Department Crime Lab?
To Oakland?
Yeah.
Or
where did you go? I'm sorry, San Francisco.
San Francisco. Basically because they asked me to come and help them implement DNA testing in their laboratory. And I knew the laboratory director in San Francisco was one of my colleagues in Oakland. So we knew each other well. And so she asked me to come and help her.
So essentially in the early to mid 90s, you assisted the implementation of DNA technology at 3 different state crime laboratories. Is that right?
I essentially did it rather than assisting.
Got you. And after you implemented DNA testing at the San Francisco Police Department Crime Laboratory, where did you go?
I went to work at Forensic Science Associates in Richmond, California.
And can you tell the court a little bit about Forensic Science Associates? What type of laboratory it was?
Yes, Forensic Science Associates was a small private forensic laboratory in Emeryville, California, which later moved to Richmond, California. But while it was in Emeryville, they shared space with the corporation that invented PCR-based DNA analysis techniques. And so one of the partners in that laboratory, Dr. Edward Blake, recognized that PCR-based testing could be very helpful in the forensic arena. So he worked very closely with them to develop the technique for forensic testing. And so basically when I got the opportunity to go to work with him, I took that opportunity.
And the PCR-based technology that you described, Dr. Blake, helping pioneer in the forensic context, is that still utilized today, that technology?
Yes, that is the technology that is used worldwide by virtually every crime lab, and by in most applications where people are working with the genetics of DNA.
And did you stay working at Forensic Science Associates until you joined Forensic Analytical, or how did that work?
Well, essentially in 2011, Forensic Science Associates and Forensic Analytical merged. Forensic Analytical essentially purchased or bought Forensic Science Associates, and the 2 laboratories became one.
So just to summarize, for about the first 15 years of your career, you worked in law enforcement laboratories and helped implement DNA testing there, and then moved over to a private DNA laboratory for the past about 2 decades, little over.
Correct.
We're briefly going to talk about your education. If you could just describe for the court your formal education, that would be helpful.
Sure. I have a Bachelor of Science degree from Texas A&M University in College Station. I have about 23 credits towards a master's degree, most of that in human physiology. And I have 3 credits towards in graduate molecular biology from the University of California at Berkeley.
And do you hold any licenses or certifications related to your work?
I am certified by the American Board of Criminalistics, and the state of Texas requires licensure, so I am licensed by the Texas Forensic Science Commission to conduct DNA testing for the state of Texas.
And what is the a certification by the American Board of Criminalistics? What field is that in?
Well, that is an organization that essentially initially was set up by the California Association of Criminalists to develop a testing platform, if you will, for because there is no governmental regulation, there are no other licensings to more or less regulate forensic practitioners. We set that process up so that analysts could take various tests to demonstrate their knowledge and their competence in the field. And that since has been taken over by nationally by the American Board of Criminalistics, so that any practitioner, any analyst, whether they're in a law enforcement laboratory or in private practice, can avail themselves of these tests and become certified.
Are you also a member of any professional associations?
Yes, I'm a member of the California Association of Criminalists and the American Academy of Forensic Sciences.
And you touched upon this a little bit earlier with regard to accreditation. You testified that accreditation enables laboratories to participate in the CODIS DNA database system. As part of that accreditation, does your laboratory undergo external audits?
Yes, we are required to adhere to the standards of ISO 17025, which regulates testing laboratories, and also the federal or the FBI quality assurance standards, which were developed according to the 1994 DNA Identification Act. So we have to comply with those standards, and we have to demonstrate and prove that we comply with those standards by being audited every other year externally. Both the ANAB accreditors and agent of the FBI will come in and do a physical audit, which lasts 2 or 3 days, of our quality assurance system, our physical plant, the analyst qualifications. They will observe us doing casework, that sort of thing, to prove that we are adhering to these various standards. And we have to do that every other year. And at the same time, every other year, we have to submit an internal audit that we have conducted, documenting any changes that have been made and demonstrating that they conform with those standards as well. And each of our analysts also has to take 2 externally administered proficiency tests every year.
And do you undergo proficiency testing as well?
Of course.
I'd like to turn to talk briefly about a little bit more about the casework that is performed at Forensic Analytical. Approximately what percentage of your DNA work is performed for police and prosecutors, I guess law enforcement in general, in furtherance of a criminal investigation or a prosecution?
I'd say that comprises about 40% of our caseload.
And so these would be pretty much pre-trial cases.
Correct.
And are they crimes that occurred recently, or do they include old unsolved cases? How would you characterize the recency of the evidence that you're typically examining?
It's both. We examine evidence that is decades old, and we examine evidence that is very recent for law enforcement. The old stuff is typically cold cases that are being reopened and investigated, primarily to try to take advantage of either CODIS or genetic genealogy type tests. So yeah, it's quite varied.
And we're going to come back to talk a little bit more about, well, why don't we do it now? Could you explain for the court, what when you're talking about genetic genealogy, what is that specifically?
Genetic genealogy is a different kind of forensic DNA testing that is used primarily when comparisons of a DNA profile, an STR-based DNA profile, to persons of interest, and also probably to the National CODIS database, has failed to make an association or provide an investigative lead or identify a person. So in those instances where there is sufficient biology, that DNA can be typed with a different technology that will help produce a particular one, or maybe one or two or three possible family surnames that can then be investigated as to a possible source for the crime scene biology.
And just to put it in layperson's terms, basically genetic genealogy is performing a specific type of DNA testing and then using commercially available genealogical databases to try to identify the source of that DNA. Is that right?
We'll try to identify a person of interest, and then once the person of interest is identified, then the traditional autosomal STRs are compared.
Okay. Thank you. We're going to return to that a little bit later. I just wanted to finish up with the casework that you perform at Forensic Analytical. You said approximately 40% of your work is done on behalf of law enforcement attempting to develop a suspect in open cases. And approximately, how many post-conviction cases has your laboratory performed? So cases like Mr. Payne, where somebody is convicted and seeking access to DNA testing to prove innocence.
I personally have done probably 150 post-conviction cases. The laboratory as it exists now has done about 165 post-conviction investigations.
And would you say that, some or many of these cases are from the 1980s, like Mr. Payne's?
Initially, that's when most of them were. I've done a lot of cases from the 1980s, yes.
And in these post-conviction cases, where the defendant is seeking testing in support of an innocence claim, are you typically retained defense?
Yes, for the most part, we are retained and compensated by the defense or a public agency. But also most of the time they are joint investigations in which the state and the court share in the, in any evidence that is developed by the investigation.
So when you say joint investigation, to clarify, you're referring to the fact that by the time the evidence gets to you in these post-conviction cases, it is sent to you pursuant to a court order in which all parties are informed at the same time of the results of DNA testing and there is a process set out. Is that meaning by joint investigation?
And that's correct. You're starting to break up a little bit, but I can still follow you.
Okay.
That's
hopefully the folks in the court can still hear. I can't see any. I'm looking for a thumbs up, but I can't see anything that close. I think Barry's saying yes. Okay. So just, to reiterate, in case I cut out, you mentioned that in the post-conviction context, you are hired by the defense and compensated by the defense, but these are joint investigations in the sense that the evidence is sent to you pursuant to a court order and all parties learn about the test results at the same time and receive copies of the results and participate in the process. Is that right?
That's correct.
Okay. And of these cases where the defense has retained you to do the post-conviction testing and your lab has been able to obtain results that are informative as to the identity of the assailant, what percentage of these cases has your test results confirmed the defendant's guilt?
It's about 50-50. It's probably leaning more towards the inculpatory side nowadays, but I personally have probably 50-55 exonerations and about 55 inculpations. So 50-50, 65 or 55-45, something like that. So, and most of the investigations are usually successful. There's very few in which we fail to find relevant biology that produces a profile that is probative and generally dispositive.
And when you say generally dispositive or you refer to probative evidence, do some of these cases involve the identification of the biological evidence from the crime scene through the CODIS database?
Of course.
Okay. Mr. Kill, I just want to talk briefly about some of the work that you've done specifically on cases from Tennessee. Are you currently working on any cases, any criminal cases from Tennessee?
Yes, right now in the laboratory we have a case from Bradley County, the Minton Post investigation. We are working on that right now.
And
This
I'm sorry, I can't hear you, Your Honor.
Go ahead, speak up, Mr. Jones. Hear Mr. Jones speaking. Go ahead, Mr. Jones.
Cases.
Did you hear the objection?
I couldn't hear the objection, Judge. I'm sorry.
Can you hear me now?
I can hear you now.
My objection is relevance of his work on other cases. I will stipulate his qualifications as an expert.
I think it's great if the state wants to stipulate to his qualifications as an expert, but I do think that the work that Mr. Keel has done is doing now and has done within the state of Tennessee on other cases that are stored in similar conditions to the evidence that's being stored now, both that he's currently have been approved pursuant to the statute for testing, and also cases that he actually was sent and obtained results on and testified to the state, are relevant to the capacity of DNA testing 20 years later to go back and get results that are meaningful on evidence that the state's contested. So I think that his ultimate opinion about the ability of DNA testing in this case to identify DNA that belongs to the assailant and to exclude Mr. Payne is based on his experience doing Facebook, in part.
Regarding cases like this, what's your response? Okay. Well, as far as it relates to cases like this with evidence similar that are similar to this particular situation, I'll allow it. Generally, Tennessee cases, I don't see how it's relevant. If you can restrict your question, evidence in a similar situation to Payne, that's fine.
Okay. So I will move on from the other Tennessee cases and return to them in the context of in a little bit later. I think that I understood the court to say that we could discuss this in the context of similar evidence. And so I will return to it in a bit. Mr. Keel, just to, follow up a few more questions on your qualifications, and it appears that the state is, not contesting you to be qualified as an expert, but just a few more questions. In the, nearly 4 decades that you've been performing forensic testing, approximately how many cases have you worked on examining biological evidence in an effort to identify biology left by an assailant?
I'd say it has to be well over 1,000 cases and several thousand specimens and many thousands of samples from cases over 30-something states within the country.
And I take it that you have testified before in criminal proceedings.
Yes, many times in, I think, about 23 different states.
23 different states, and approximately how many times have you been qualified as an expert?
I'd say in excess of 75 times easily.
So I'm not in the courtroom, but co-counsel Kelly Henry has a copy of your CV, which I believe was identified for this proceeding as Petitioner's Exhibit 2. It's hard to show it to you right now, Mr. Keel, but it was attached to the declaration that you provided to the court that was attached to our petition for post-conviction testing. Does the declaration, does the CV that was attached to your declaration accurately list your background, education, your work experience as a forensic biologist and DNA analyst?
Yes.
So I would move to admit petitioners 22 into evidence. And
This is exhibit 22.
I would offer Mr. Keel as an expert in forensic psychology and forensic testing.
I'm sorry, I didn't understand.
Any objection to Mr. Kill?
In what capacity? I couldn't hear what she said.
Okay, I'm sorry, Ms. Buck, if you could again state what you're asking him to be qualified as an expert in.
Yes, I would offer him as an expert in forensic biology and DNA examination and testing.
No objection, he'll testify as an expert in those fields.
Thank you. So, Mr. Keel, we talked just a moment ago about your declaration to the court, which was provided to advise the court on the capacities of DNA testing in this case to identify assailant DNA. In your declaration, you indicated that you had reviewed crime scene photos, trial testimony, and serology reports. Is that right?
That's correct.
And since the time that you issued that declaration, you have been provided with additional materials, including additional crime scene photographs, represented to be from the district attorney's file, the TBI case file, the West Tennessee Regional Forensic Center case file. Is that right?
That's correct.
And is your testimony today based on your review of all of these materials?
It's based on my review of those materials and my personal experience as well. Yes.
And what, in addition to those materials, or based on those materials, what is your basic understanding of the crime that was committed in this case and the injuries to Miss Christopher and the children?
My understanding is that a young lady and her two children were killed very violently. The adult female victim was stabbed numerous times and experienced numerous defensive injuries as well, and that both of the children were stabbed many times and one of them survived. That's my understanding.
And in terms of the physical evidence that was collected during autopsy and from the crime scene, is it your understanding that fingernails, sexual assault evidence, blood evidence, and a murder weapon, among other items, were collected?
Yes.
And to your knowledge, has any DNA testing been performed in this case at the time of trial or any time subsequently?
My understanding is no DNA testing has been conducted on anything in this case at this point.
And there was some basic serology done at the time of trial, correct?
Correct. Correct.
How would you describe the difference between the testing that was available at the time of trial and what's available today in terms of the ability to recover assailant DNA and to identify who that person is?
Well, certainly at the time of the trial, the techniques that were used were the state of the art. I mean, I was using those same techniques at that time, but with the advent of DNA technology, the techniques that we have available to us today are simply exponentially more sensitive and more discriminating in terms of being able to tell us who might be a potential contributor of biological material from a crime scene. And also we now know, given this extraordinary sensitivity, we now know that we can pursue items of evidence that we might not have considered at the time of the trial.
And so before we turn to a discussion of specific items, could you tell the court what conclusion did you reach, if any, about the ability of current DNA technology to identify assailant DNA and to match that DNA to a known individual?
Well, certainly, I believe that there is the potential to develop and to locate biology from the assailant among this physical evidence, and to produce a DNA-based profile that could essentially identify this person.
And in terms of the ability of DNA to, in terms of the ability to recover assailant DNA, could you briefly talk about, what is touch DNA or contact DNA?
Touch DNA refers to biology that is transferred to an object primarily simply through physical contact, either touching it or holding it generally for brief periods of time. But it also refers to biology that might be transferred, for example, to, in this particular case, to the handle of the knife, or to fabrics that have been used to perhaps clean up, or whatever a person is going to transfer their biology to those substrates just during the course of handling or using them.
And what is YSTR testing?
YSTR testing refers to the male Y chromosome. Only males possess a Y chromosome, and we are able to exploit that fact by doing DNA analysis of STR genes that are only on the male Y chromosome. And in that way, we are able to, if the male DNA is commingled with female DNA, we are essentially able to render the female DNA invisible so that we can isolate the male DNA and generate only a male YSTR profile.
And what is STR testing? Just standard STR testing?
Well, essentially there are two branches of STR testing. There's the autosomal STR testing and then the Y chromosome testing. The traditional autosomal STRs are those genes that are scattered among the various chromosomes, and there are many of them, and we are able to use about 20 to 24 of them just in a routine analysis where we can type all of them at the same time, or attempt to type all of them at the same time from a small amount of biology that's been recovered from a crime scene.
And you had mentioned before that some of your early work involved implementing, working with Ed Blake to help to develop PCR-based forensic testing and implementing that technology at laboratories. Is STR different from PCR testing?
I'm sorry, did you say is STR different than PCR testing?
Yeah, can you explain the relationship between the two of those to the court?
Yes, all of the STR tandem repeat genes are typed using PCR testing. PCR is just an acronym for the polymerase chain reaction. So all of these genes, whether they are autosomal STRs or whether they are Y chromosome STRs, they are all typed, if you will, using PCR or the polymerase chain reaction.
So STR testing and YSTR testing technology for developing assailant DNA, whether it's from touch or some other biology at the scene. I'd like to turn a little bit to talk a bit more about the tools that exist for linking that crime scene, that DNA from a crime scene to a known individual. You talked a bit here and there about CODIS. Can you tell the court a bit more about what is CODIS? What's the purpose of the CODIS system?
CODIS simply stands for the Combined DNA System, and that is a data bank of DNA profiles, and they are convicted offenders, they are arrestees, they are forensic unknown profiles that are produced in crime laboratories. And so all of these profiles are unique to a particular person. And so they have been assembled all in one place, and any unknown DNA profile can then be compared to this library, if you will, or this data bank of millions of DNA profiles to determine whether or not there is a similar or a matching profile in the CODIS data bank, and thereby identify the source of crime scene biology.
And approximately how many profiles are in the CODIS system, in this database right now?
Right now, there are over 14 million offender profiles. There are over 4 million arrestee profiles, and there is over 1 million forensic unknown profiles. So there's over 19 million profiles in the CODIS data bank.
And is it your understanding that when the database first was being built, most states went to require any person convicted of a homicide or a sexual assault to submit a profile to CODIS?
Correct.
And as time has gone on, that has expanded in terms of convicted offenders and who is required to submit a sample to CODIS. Is that right?
Yes, most or many states now have a statute that requires just anyone who is arrested to submit a sample for inclusion into CODIS.
And who maintains the CODIS system? Who operates it?
The FBI maintains the CODIS system, and each of the states have a state CODIS administrator, and then the various laboratories at the local branch have their own local CODIS administrators.
Can you remind me how many profiles did you say approximately were in the database today?
It would be almost 19 million.
And most of those were of convicted offender profiles, correct?
About 14 million, yes.
So if your laboratory was to perform DNA testing in this case, and you obtain a profile from crime scene evidence that has enough genetic information that it can be searched in CODIS, could your profile actually be entered into the CODIS system to be searched against these 19 million profiles?
Of course, we've done it many times and had many hits.
Okay. An issue.
In addition to searching a sample in CODIS, you mentioned that genetic genealogy is another tool for matching crime scene evidence to a known individual, correct?
It's a way of identifying a potential family association. Yes.
So would it be more accurate to say through DNA testing and a search of the genetic genealogy databases, a suspect can be identified to compare to the crime scene evidence?
Of course.
And how long has genetic genealogy been available as a tool?
Ms. Bodkin.
Good.
Can I stop you? I mean, I should have stopped you a while ago. I don't think anybody objects to Mr. Keel being an expert. What I'm interested in is whether or not the items are capable of being tested. Can we move on?
Yes, Judge. Let's move on to the other.
Thank you. Fascinating, but I mean, I'm a fan of DNA. I believe in it. I don't think Mr. Jones has an objection to any of this. He's an expert. Mr. Keel's an expert. Sounds fantastic to me. But I'm concerned about whether or not these items are capable of being tested.
Okay. Yes, Judge. We will address that immediately.
Okay. Thank you.
Okay. So, Mr. Keel, let's turn to begin with Lauren, hopefully you're and right here can access the screen. We're going to turn first to talk briefly, Judge, about the fingernail clippings. And I'm only going to talk briefly because I know that, you know, as of this moment, the state is maintaining that this evidence no longer exists. But there's no record that the fingernails have been destroyed. And we have had numerous cases, even last week, an exoneration in Florida, based on a CODIS hit, where in 2007, our client asked for DNA testing and was told that the evidence didn't exist, and then a slide was found at the ME's office just a few weeks ago, and Mr. Keel's lab, in fact, did the testing, and there was a CODIS hit to a serial assailant. So I think it's just worth briefly talking about the fingernails because they may turn up. And so we would like the court to just consider the relevance, but I will do it briefly and get to the items that we have confirmed exist. Mr. Keel, can you see the screen?
Yes.
Okay. So I want to direct your attention to what is labeled as Petitioner's Exhibit 3. What is your understanding of what that photograph depicts?
The photograph has gone away, but that the photograph depicts one of the hands as it lay on the floor, the victim, the adult female victim's hand as it lay on the floor at the scene, and then the medical examiner's diagram of various wounds on her hands.
Okay, and can you see the screen anymore or not on your end? We'll continue, but can you see the diagrams?
1 second, I'm seeing it, but Mr. Keel's not seeing it. He's not seeing the give it up.
Is that Vanessa or Lauren?
Vanessa.
This is
I
Vanessa.
saw it for a moment.
Alan, Miss Alan Keel, can you see it on your, it sounds like our Andrew Porter can see it, so, and I can see it. So I'm trying to figure out, it's not coming up on your right underneath the, do you have gallery view up, or it's, I don't want to. Do you have another copy of the photographs that you might just be able to look at on the side?
Yes, I have it. I can look at it.
Okay, fantastic. And
Right,
so,
He's got it.
great, thank you. When you talked about wounds, Mr. Keel, is there any, or have these been classified as defensive wounds?
Yes.
And what are defensive wounds exactly?
Well, for the most part, they are wounds that one sustains when you're being attacked with a sharp object, and in trying to ward off the attack, your hands and your arms or whatever you use to try to parry the blow become either cut or stabbed in the process. So.
And what in general is the probative value of fingernail scraping or cutting evidence?
Fingernails have long been recognized as potentially holding biology from one's assailant. And at the same time, we know that biology remaining a person's fingernail is while you're alive, is a relatively short period of time. So that finding biology foreign to oneself under the fingernails, especially in the context of a criminal assault, it's likely that biology is relevant.
And typically, what is the source of biological underneath the fingernails? What type of, is it blood, skin cells? What type of biological material is it?
It can be blood, it can be tissue from scratching, skin cells, that sort of thing. I've recovered semen from under fingernails, so you never really know until you look.
And in this case, based on your review of the records, was there any indication that Ms. Christopher had foreign DNA underneath her nails?
Yes, that's already been demonstrated from the conventional genetic work that was done, pre-trial. We know that the Tennessee crime laboratory determined, or perhaps it was the medical examiner's office that determined there was foreign ABO blood group substance detected on two of the victims, the adult female victims' fingernails. So we do know that there should be foreign biology and foreign DNA under her fingernails. And so if that evidence is available, we should be able to do DNA testing on it today and likely produce a profile unique to a particular person.
And would that be potentially a profile that could be searched in the CODIS database to be matched to a known individual?
Certainly, potentially, yes. I mean, even though I would expect there to be a significant mixture of DNAs from the victim and the foreign biology source, we are able to to deduce the foreign profile from that mixture, either just intuitively, manually, or using a software that helps us sort this. It's called probabilistic genotyping software that help us sort out mixtures, or we could rely upon Y chromosome testing to generate a a specific male DNA profile for comparison to any male interest.
And you performed DNA testing in a number of cases, dozens of cases on fingernail evidence, correct?
Yes, I've examined over 50 sets of fingernail, person fingernail evidence specimens, yes.
And sometimes those fingernails have been collected by being clipped, and sometimes they're scraped, and sometimes they're even smeared onto a piece of paper, right?
It's either the fingernail clipping itself or the material that a medical examiner or a crime scene investigator has scraped from the fingernails. They may have swabbed the nails. So it exists in various forms, but essentially it is an attempt to capture whatever biology is available primarily on the undersurface, underneath a victim's fingernails.
And your laboratory has been successful generating profiles in various ways that evidence has been collected on fingernails decades after the crime was committed. Is that right?
That's correct.
Okay. And so is it your opinion that if the fingernail evidence is located in this case, it is capable of being tested to identify assailant DNA?
Oh, there's no doubt. Well, it's certainly capable of being tested and determining whether or not there is DNA foreign to the victim. And then that DNA can be compared to any person of interest.
Either through a direct comparison or through, if eligible, a search of the CODIS database.
That's correct.
Let's move on to the next item of evidence and talk about what was introduced at trial as State's Exhibit 25, the murder weapon, which was 12.
Okay.
All right. Lauren, I don't know if anybody else, have we moved to the next picture? Are we on to,
Yeah. Yeah, can you see it?
I can't, but if everybody,
I don't think you've moved on.
Does it still show the fingernails?
yeah.
Yes.
All right, let me stop sharing for just a second and then I'll restart. I'm having issues sharing my screen again. I'm not sure if the presenter switched over again.
Yeah, this sounds like a good time for a recess. We've got photos tonight here. But let's stand in recess. That's very nice.
I apologize. I couldn't hear the court's response.
You're on. Go ahead, Ms. Patrick.
Okay. Mr. Keel, if you can see on the screen what is labeled as petitioner's exhibit number 5 and petitioner's exhibit number 6, what is your understanding of what those photographs depict?
Well, I can't see them on the screen, but I do have a copy of it. My understanding is that the photograph is petitioner's exhibit number 5 reflects the outside of a paper bag showing a chain of custody type label on the bag. And then petitioner's exhibit number 6 shows either the back of the bag or another bag, and it shows the labeling that's on the bag itself.
And does that labeling correspond to the item that was introduced ultimately at trial as state's trial exhibit number 25, the butcher knife from the crime scene?
That is my understanding, yes.
Mr. Keel, you previously testified that you have performed post-conviction DNA testing in about, I believe you said 155 cases around there.
Yes.
How common is it for you to receive evidence that is packaged similarly to the packaging that we see here for the murder weapon?
Virtually all of the physical evidence that we receive in any context comes to us in a similar packaging format. It's a brown paper bag. A grocery type bag is often employed. Sometimes specimens come in boxes, but typically this is the sort of packaging that one uses and one encounters in just about every case.
And when evidence comes to you, is it sometimes in sealed bags and sometimes in bags that are not sealed?
That's correct.
And even if a bag is unsealed, have you still been successful in recovering DNA attributable to an assailant?
Oh, many times, yeah. Yes.
And in the cases that you've worked on, the post-conviction cases, is it common for evidence to have been stored for decades with a clerk of court?
Yes, it's not uncommon at all.
And in those cases that you've received evidence similarly packaged, you have been able to obtain conclusive results that either confirm guilt or, in some instances, exonerate a convicted individual.
In virtually every case, yes.
Sorry, you cut out. What did you say?
I said in virtually every case.
So let's turn to the next photograph, which is a picture of the knife itself. So we're going to turn, I think just on paper at this point, to what's labeled as Petitioner's Exhibit 7 and Petitioner's Exhibit 8.
Okay.
And can you describe what we're seeing in these two photographs?
Yes, Petitioner's Exhibit 7 is the inside of the bag showing the contents, which is the knife and a paper document.
And Petitioner's Exhibit 8
Oh,
Mr.
Petitioner's Exhibit 8, I'm sorry, is the, I believe that's the contents of the bag. There is a knife and then a white piece of paper. And I believe, I'm not sure about the ruler. I don't know if it's there just for scale or if it was in the bag itself. I don't know the answer to that question.
I think for clarity, Petitioner's Exhibit 8 comes from the district attorney's file that you were provided from the original examination of the evidence. Does that seem familiar to you?
I don't recall at this moment in time.
So can you explain for the court, what would the potential sources of assailant DNA be on this item?
Oh, certainly. We know that each of the victims was stabbed, many times. So one would certainly expect there to be assailant biology on the handle of the knife, and it's not unusual in these of prolonged and violent assaults that the assailant himself gets injured, and often on the hand that is wielding the knife. So it would not be surprising to find assailant blood on the knife. So those would be the two primary sources of biology, potentially from the assailant, that one might expect to recover from the knife itself.
Okay. I'm just going to say I'm getting a little bit of feedback if there's a way to address that, but I'm going to continue on. So the sources of assailant DNA would be skin cells, you said, from the assailant wielding the knife, and potential blood from the assailant being injured during the repeated stabbings. Is that right?
That's correct. That's correct.
Okay. And how would you go about testing the sample?
I would separate the handle from the blade. I would primarily swab the surface of the blade. I would probably take, depending upon how it actually presents itself, I would probably take a swab that sampled blood in more than one area, and then I would attempt to sample areas of the handle that have as little blood associated with them as possible.
And the purpose of that would be to try to get contact DNA?
It would be to try to get contact DNA that is not commingled with so much potential victim blood, so that it wouldn't be overwhelmed. Contact biology typically has most skin cells have lost most of the DNA that's in them. So if you have touch DNA or skin cells commingled with blood, the DNA from the blood can overwhelm the foreign biology. But that limitation could be addressed potentially with YSTR technology. But in order to get the clearest autosomal profile, we would try to minimize the amount of DNA from victim blood in a sample that we're trying to get contact biology.
You mentioned that you could potentially perform YSTR testing to target male DNA only on the knife In addition to that, is it possible either from the testing of the skin cells or the blood, if the assailant injured himself, to obtain a profile that can be searched in CODIS and matched to a third party?
Of course, especially if there is, foreign blood potentially from the assailant on the handle of the knife, or even on the blade, or on any other item for that matter. We should be able to produce a CODIS eligible profile from that blood, even if it's commingled with victim blood. We should be able to deduce a separate profile from that sample. And given that we are now able to type over 20 genes from a single sample, and the CODIS guidelines require only information from at least 8 of those genes, then even if the profile is partial, it's likely that it will be eligible for CODIS.
So I want to talk for a minute about that, which is just, you made a reference to the CODIS requirements changing, and also the testing for 20 locations, genetic locations. And are those developments in DNA technology developments that have occurred since Mr. Payne's previous application for testing in 2006?
Yes, certainly in 2017, the switch was made to increase the core number of CODIS loci from 13 to 20. So now we are required to at least attempt all 20 loci, and those have to include the previous 13 core markers, if you will. But because most of the profiles that are in CODIS do not include many of these genes, we only need results from 8 of the previous 13, and the profile need only match a statistical rarity of about 1 in 10 million for it to be eligible for search in CODIS.
So in simpler terms, there are profiles that since 2017 could be developed and searched in CODIS that previously would have been ineligible for CODIS. Is that correct?
That's correct, yes.
And the testing kits that test for 20 markers, are those more sensitive and more discriminating than previous test kits that were being used?
Yes, they're both. Now, using today's technology, instrumental and the DNA typing kits, we are able to get more information from less DNA. And in particular, we are able to get more information from the STR genes that are smaller and will persist longer during the degradation process, or as time passes, such that we now it's very likely that with most samples we will produce, even if this profile is partial, we will produce enough information for it to qualify for CODIS from a single sample.
And my last question on this point is, you had mentioned previously that, today there are about 19 million profiles in CODIS. So if we do the testing today, a crime scene profile, a male DNA profile from the crime scene in this case could be searched in CODIS, and it will be compared against 19 million other individuals to see if it matches. In 2000, approximately in 2006, when Mr. Payne previously requested testing, do you have a sense of how many profiles were in CODIS at that time?
Yes, there were about, I think, just a little fewer than 4 million.
So is it fair to say that given the new testing kits, the new technology, the new requirements from CODIS, and the millions more profiles that are on file, it's possible to yield DNA from the assailant that matches a known person that was not possible to do in 2006? That may not.
That's correct.
Okay. I want to turn to a little bit about this issue of contamination, because the state is arguing here that because the knife and the other evidence in this case has been sitting in a clerk's office, in the clerk of court's office over the course of decades, that people could have come and gone and potentially touched it, and therefore DNA testing is incapable of identifying assailant DNA that excludes Mr. Payne. Can you address that point for the court?
Certainly, that would not be a cause of concern for me, or essentially for any other DNA analyst for that matter. With regard to contamination, it really doesn't matter. The context of the specimen doesn't really matter. No one can know a priori. I'm sorry, I'm getting another conversation or something.
I think there might be, does anybody have their cell phone on? Because we're getting from IT that maybe their cell phone's too close to the phone. I'm gonna certainly turn mine off or move mine, but if that's a possibility for you to turn yours off, Mr. Keel, maybe that would help. I think we may be the only people on who are not muted, so we'll try that.
Okay. With regard to contamination, as I was saying, whether it's a recent specimen or it's a decades old specimen, no one can know a priori how many contributors there are to a specimen. And that's a given in the scientific community. We, it's collected at the crime scene, or it's taken out of a bag that's been stored for a period of time. Given that seals on bags help, diminish the potential for inadvertent contamination after a specimen has been collected. Nevertheless, the analysts themselves, we have no way of knowing how many potential contributors there might be in a result until we do the test. And then we can assess the results based on what we know about the case and what the data itself shows. So, if the potential for contamination rendered a sample to be untestable, simply that potential, then we wouldn't be doing this work at all.
And that's both pre-trial and post-conviction, right?
Of course.
So if you obtained a profile from the handle of the knife, from skin cells, how could you determine that this profile came from the assailant as opposed to somebody who touched the knife at the clerk's office since trial?
Well, I would expect that if I am, first of all, I would expect that the samples that I collect from the knife handle to have some measure of blood associated with them. So whether or not that the DNA profile that I get originates from blood will likely depend upon the robustness of the profile. So hypothetically, let's assume that a robust male profile, and let's say it's not compatible with the male victim, is produced from a swab of this knife handle. That result is more likely to come from an assailant, a person who was there and bled on the knife, as opposed to someone who may have casually handled or touched the knife during its history with the court or with the laboratory or whatever. So that type of judgment will be based on the data itself. If there are some really trace level, low level alleles that one cannot associate into a particular profile, then one may not be able to make a determination, about those alleles and associate them into a profile. So, whether or not they come from the crime scene or from inadvertent contamination then becomes academic.
And what role could CODIS play in helping to establish that the DNA profile obtained is not a result of contamination?
Well, certainly if we were fortunate enough to get a foreign profile that.
Hang on a second. Ms. Potkin, would you repeat the question? The prosecutor couldn't hear the question.
The question was, what role does CODIS play in helping to determine whether or not a profile belongs to an assailant as opposed to contamination?
Repeat that you're still,
what role does CODIS play in the determination of whether a profile from the crime scene evidence comes from the assailant as opposed to contamination?
Well, certainly if a profile matches a convicted offender in the CODIS in the CODIS database, then it's certainly, at least in my judgment, that biology comes from, is relevant and comes from a potential assailant rather than someone who inadvertently handled the knife in at the crime scene, or as it was being collected by law enforcement, or someone who handled the knife pre-trial during its examination, fingerprinting, that sort of thing, or even as it sat on the shelf in the clerk's office, or even in my laboratory if it comes here for testing, because those individuals are trusted individuals. They're not likely convicted offenders whose profiles are in CODIS.
So, to put it succinctly, the fact that the knife may have been touched by some other person unrelated to the crime prior to trial, at trial, as it's been on the shelves in the past few decades, does not undermine your ability today to test the knife, to get assailant DNA, and to potentially identify the source of that DNA through CODIS.
That's correct. In no way is that potential undermined or even a concern.
You had provided me, if you could turn to the next picture, of what has been labeled, petitioners exhibit 9, 10, and 11. And if you could tell the court what those pictures are of.
It's essentially, this is an example of the packaging for a knife that was believed to have been used in a murder. And it is a photograph of one aspect of the knife itself. And then it is swabs that we made here in my laboratory of the handle of the knife. So what you see is a packaging specimen very similar to those that are present in this case. And you see then in petitioner's exhibit 11, you see from the swabs that this knife has been processed for fingerprints with fingerprint powder, and the swab itself is literally caked with fingerprint powder. And the knife itself was recovered at the intersection of a street in a public trash can. And so, the fact that the history of the knife and the fact that it had been processed by another laboratory for fingerprints, and from this swab, we developed a full profile for an individual who turns out to be the defendant in the case. The fact, the packaging or the history of the knife, and given that it had been treated for fingerprints prior to the DNA testing, had no impact on the ability of forensic DNA testing to produce a reliable result.
And if we could turn to the next photograph, which should be labeled washcloth, State's Trial Exhibit 34.
Okay.
Can you discuss what we're seeing in petitioner's exhibit 12 and 13, the two photographs on the slide?
Yes, in exhibit 12, we're seeing the packaging for the washcloth and how it was labeled once this package was designed to hold this particular piece of evidence that was collected from the crime scene. And then exhibit 13 is the item itself, which is a white apparent washcloth, which shows apparent blood stains concentrated towards the middle and then scattered all over the surface of the fabric. We see two void areas, two cutouts where it has been sampled previously. And we see the previous examiner, and I believe the collectors, identifying marks on the washcloth as well.
And what's your understanding of the previous testing or the testing that was done at the time of trial on the washcloth?
Oh, based on the reports and the bench notes that I have, blood was determined to be present on the washcloth, and it was determined to be human blood. And then various attempts were made to do conventional enzyme testing, which was not successful.
And what is the potential source of assailant DNA on this item? What would you test for?
I would approach it similarly to the knife. I would sample the concentrated blood stains. I would sample more or less isolated areas that are stained with blood. And I would also sample the perhaps a larger portion of the central area of the washcloth that is not as visibly stained with blood, in an attempt to get biology from someone who may have used the washcloth to wipe either their blood or victim blood or both, from in an attempt to clean up. So it would basically depend upon how the washcloth presents itself as to the number of different samples that we might take.
So given its history, the washcloth could contain blood and or skin cells from the assailant.
That's correct. Who knows? It might have semen on it. I don't know.
And your understanding of the case is that it was the state's theory at trial that the adult victim was sexually assaulted, correct?
That's correct.
Is there anything that's unusual or deficient about this packaging of the washcloth that's depicted in Petitioner's Exhibit 12?
No, it's fairly typical.
Okay. And we started to touch upon it a little earlier, and it might be a good place to do it now. One of the cases in which you performed testing in Tennessee, which you discussed in your declaration to the court, involved the case of Melvin Crump.
That's correct.
And can you explain to the court, discuss a bit about the re-exam, the most recent testing that you did in that case, what evidence you received, and how long after the original crime it was examined?
Okay.
Objection. Hello?
Okay, objection.
Yes. Objection to the relevance. What's the relevance?
Well, the relevance is that it involves a case where the state of Tennessee hired Mr. Keel to perform testing on, I believe, a very similar item about a decade and a half after the crime, where the evidence had been similarly stored, and he testified at a trial that resulted in the defendant's conviction after identifying DNA on a similar item. So it speaks to the state's concern that somehow storage undermines the ability to obtain useful DNA results.
All right. Well, let me hear some more about that other case. And you can go ahead and tell me some more about that other case so I can try to make a ruling on it. I don't know anything about that other case. That was a washcloth, you're saying?
I'm sorry, are you asking me, Your Honor?
Yes.
Was that a washcloth in the other situation?
Yes, there was a washcloth, and there was a towel, and there was a bed sheet.
Well, I'll overrule the objection. You may testify regarding it.
Okay, Vanessa, could you repeat the question, please?
Sure. Mr. Keel, could you, we don't want to get into too many details, but just generally describe when the crime occurred and the re-examination you were requested to do in the case.
Yes, the case initially occurred in 1988, Davidson County, and in 2005, we were asked by the State Attorney General's office to re-examine some of the evidence that had been examined back in 1988, and I was able to find semen on a towel and a bed sheet that produced a full profile of the suspect at the time, and then I testified at his subsequent trial, and he was convicted.
Okay. And do you recall in that case where the evidence had been stored that was submitted to you, to your laboratory?
Not off the top of my head, but I can come up with that later. I mean, I have chain of custody records.
Thank you. We will move on to a brief discussion of some of the other items that were mentioned in your declaration. In connection with the murder weapon and the washcloth, you've discussed the ability to get contact DNA from these items handled by the assailant, and also blood, DNA from blood if the assailant was injured during the attack. Have you had experiences in other stabbing cases where an assailant was injured and you recovered DNA from blood?
Yes.
And you, in your declaration, had discussed a number of other items that had been recovered from the scene that contained blood that may or may not have been also handled by the assailant. Curtains, a rug found next to the adult victim, a cloth next to the adult victim's body, a stuffed animal, children's clothing, and the children's clothing did not have blood. The other items tested positive for blood, but you had discussed the possibility in your affidavit declaration about performing testing on these items as well. And would the examination of these items be similar to the knife and the washcloth? If you could discuss briefly the potential source of assailant DNA on these items.
Sure. Basically, the approach would be to take samples of more or less isolated blood stains to see whether or not that blood is foreign to any of the victims. That would be the primary goal. And then whether or not it might be, we might be able to try to capture touch DNA or even, semen if it's there, that would just depend upon what the specimen is and the surface area and how we might be able to sample it. I primarily those specimens we would focus on trying to find foreign blood stains.
Thank you, Mr. Keel. If we could turn to the next photograph, which is labeled tampons, State's Trial Exhibit 16, and the photographs are labeled on the slide Petitioner's Exhibit 14 and Petitioner's Exhibit 15. Is it your understanding that these photographs depict the packaging of the tampon that was introduced as State's Trial Exhibit 16?
Yes, that's my understanding.
And what is your understanding, or is it your understanding that the state's theory at trial was that the tampon was being used by the victim at the time that she was attacked, and that the assailant removed the tampon and during the sexual assault?
That is my understanding, yes.
And so what would your approach be to recovering assailant DNA from the tampon?
Well, it's also my understanding that the vaginal specimens from the adult female victim tested positive for acid phosphatase, which may or may not indicate that there might be some semen associated with the vaginal swabs. Well, then that would certainly apply to the tampon as well. So certainly the tampon could be approached to look for sperm and to see if there are sperm present to develop a DNA profile that could be compared to any person of interest or potentially be in CODIS.
And have you had experience in cases testing tampon, this type of evidence before for assailant DNA?
Yes.
Again, any profile that's obtained from this item could also be searched in CODIS if an eligible profile is obtained, correct?
That's correct.
If we could move to the next photograph, which is photograph Petitioner's Exhibit 16. What does this photograph depict?
That is the tampon itself. That's laying adjacent to the bag.
And as we discussed, it's probably, contamination with this item is also not a concern, I take it.
No, not
And
to me.
Probably be even less likely that somebody would have handled the tampon without gloves in the intervening years since trial, prior to trial. Would you agree?
That would be my expectation, yes.
Let's move to the final photograph, labeled States Exhibit 39. Could you discuss what's being depicted in Petitioner's Exhibit 17 and 18?
Yes, Exhibit 17 is a photograph from the crime scene that shows, that documents the function of the eyeglasses as they were found at the crime scene. And then Petitioner's Exhibit 18, I believe, shows the same eyeglasses when they were viewed earlier.
And how, what is the process for performing DNA testing on eyeglasses? What type of DNA would you expect to find?
Well, typically with eyeglasses, one is attempting to determine the habitual wearer or the owner of the item or of the glasses. So we would sample, if we're not able to take just a global swabbing or a sampling of the specimen, we would attempt to focus on those areas that are handled most routinely, and then those crevices or places where biology might accumulate over time. And something like this, we would attempt to, like this specimen, we would attempt to avoid. We would sample the blood separately, but for the sample that we're trying to determine who was the habitual wearer of the glasses, we would avoid as much of the blood as possible.
Okay. Mr. Keogh, if the evidence from this case is submitted to your laboratory, how long would it take for you to complete testing of all of the testing that we discussed today?
I believe we could accomplish that within 45 to 60 days of receipt of the evidence.
And in your opinion, is testing of the evidence, the items that we've discussed, that we know exist, that we've just reviewed, is that testing capable of identifying DNA left behind by the person who committed this crime?
Absolutely.
And is it your opinion that through either a direct comparison with a known suspect or a POTUS search or even genetic genealogy, that DNA from the crime scene can be identified as belonging to a known third party?
Yes.
And the mere fact that the evidence could have been handled by any number of individuals during the time since it's been collected and stored does not undermine the capacity of DNA testing to identify assailant DNA and link that DNA to a third party and exclude Mr. Payne as being that source.
No, it does not.
Thank you, Mr. Keel. I have, I think we're done for the moment. I'll turn you over to Mr. Jones.
Thank you.
All right. How long? All right, we're going to take a short recess, about 10 minutes or so. Mr. Jones? Make sure you speak loudly,
That's
please.
fine. I'm gonna try speaking here, but hopefully that will help.
Okay.
Mr. Keel, can you hear me?
No, apparently.
I-
Whoa.
Alan, are you on mute?
Sorry, I was muted. I can hear you loud and clear, Mr. Jones.
I'll mute myself. I don't know if he's hearing you through me.
I don't know if you're able to hear. I didn't hear.
Now I
my-
can hear you. Now I can hear you.
My name is Assistant District Attorney. We never discussed this case before, you and I, correct?
That's correct.
And this is not my area of expertise, so bear with me. If I use terminology that is incorrect, please correct me.
I'm having difficulty understanding you.
Microphone.
Over here.
Barry, if you can, or if you speak to him.
Can you hear me now? Is this better?
I believe so, yes. Thank you.
Sure. If I use technology that's not technically correct or may cause problems for your answer, please don't hesitate to correct me. Okay?
Okay.
Talking about technology, you indicated that today's technology, as opposed to comparative, say, for instance, 2006, more sensitive and more discriminating. Did I recall that testimony correctly?
I'm sorry, sir, you're breaking up too much for me to follow your question coherently.
We need to figure this out. Or you can speak.
Whatever.
Maybe the mask, because when I spoke in the while without the mask, they could do, of course, I don't know about them.
Is this any better without my mask?
Oh, that certainly was, yes.
How do I sound, Mr. Keel?
Very good.
Once I can, a little closer, maybe.
That's for now.
You can take off.
Let me take off.
All right, Mr. Keel, did I understand your testimony that today's technology compared to, say, for instance, back in 2006, DNA technology testing is exponentially more sensitive and more discriminating?
Yes, that's correct.
In the touch DNA of today would detect DNA that was left from casual contact, incidental contact, I believe was the word that you used, and maybe not, of anyone. Is that correct?
It would depend upon the context of the sample. Certainly, objects that are simply casually handled, that are clean and then casually handled for very small periods of time, one can recover sufficient biology to get a full profile from that person. But that typically applies to recent biology and no other, commingled biology. But yes, I mean, the technology is certainly that sensitive.
And would if you do analysis on the evidence that you've been testifying about here today, would your analysis involve testing only blood or received blood, or would you test surfaces that did not appear to have blood as well?
Most likely both, yes. Uh-huh.
And your testing would determine the presence of DNA, correct?
That would be the goal, is to recover DNA from biology that would be present in any sample that we digest and attempt to recover the DNA from. Yes.
Correct. And your analysis would not determine that it was or was not assailant DNA. Is that correct?
Well, I certainly think it could be very probative in that regard. It would just depend upon the circumstances of the sample.
Would that be an issue for the lawyers to argue, or would that be the results of your testing?
Well, certainly that would guide the focus, guide how I collect my samples, sir.
The results of your testing would indicate the presence of DUI, or DNA rather, but not whether or not the person whose DNA it belonged to was an assailant. Is that correct?
I suppose that would be up to you guys to argue, yes.
Did you do any physical examination of any of the evidence that you tested about here today? Or was it was your testimony result of you were reviewing photographs and other physical documents that were sent to you?
Are you talking about in this case or some of the other cases that I've talked about?
I'm sorry, in this case, Mr. Payne's case.
Oh, no, I haven't examined any physical specimen in this case.
Whether or not there is a known sample of any of the victims' blood in this case, if it still survives, that would be Lacey Christopher, Nicholas Christopher, or Sharice Christopher.
Are you asking me if I know that?
Yes, sir.
I do not know that. I have seen specimens to that effect. I don't know whether they survive or not. No.
So it's fair to say that for what you did in your lab with the DNA testing, you identified the presence of DNA, but you can't tell when that DNA was placed there.
Well, that depends again on the sample. For example, based on your last question, if primary reference specimens from the three victims in this case were not available, I certainly wouldn't hesitate to use some of the blood from the crime scene, particularly that's intimately associated with clothing or that sort of thing, as a secondary reference. So I would know when that biology was deposited, but generally speaking, we do not know when biology was deposited. It depends upon the circumstances of the case.
So if you were to examine the items that you, in this case, the Payne case that you've been testifying about today, your results would not include an assurance that that DNA you discovered was placed on the items you tested at the time and during the crime. Is that correct?
Again, that depends upon the specimen and the sample. If the sample, for example, is semen from tampon, then I think we would all agree that that's not adventitious contamination. And then there are the blood samples, the blood stains that are already documented that were there when they were collected. Those aren't going to be new. So you just have to look at the evidence that you have and the history that you have about it, and then make those determinations or those judgments.
Well, let me ask you this about the two items you mentioned, the tampon and the knife. Are you saying that we failed to specimen on the test?
I'm sorry, Mr. Jones, I couldn't hear you.
I want to ask you, you just mentioned the tampon. And you said you mentioned that and you could testify that correctly.
It's hard to hear that question still. I couldn't hear it at all.
Regarding the tampon, I understand your testimony to be that be an example of something that you said. From that, you could say, look, that did it not wrong. I understand your testimony correctly.
I'm sorry, sir. For some reason, the important part of your question goes away. I hear the introductory part just fine, but
Get everybody to mute
I
their,
understand exactly what's happening to me with
everybody to mute their,
Just have everybody.
turn off their cell phones.
You're on, go ahead and tell them.
Okay. Everybody, if you could please make sure you're muting, everybody that's not involved in this, mute your whatever, mute yourselves, your microphones, and please make sure your cell phones are turned off if they're very close to you, okay? All right, we're gonna proceed. Go ahead.
all right, I'm gonna try again. Regarding your testimony about the tampon, are you saying that DNA from the tampon would necessarily have to have been put there during the crime?
I believe that if it's coming from sperm DNA, yes.
So you're saying that you know that Sharice Christopher did not have consensual sex for any period of time prior to this homicide, prior to her being killed?
No, I'm sorry. I misunderstood the context of your question. My answer was geared towards that biology that's on the tampon, especially if semen evidence was there either during the commission of the crime or before, and it's not some sort of adventitious contamination.
Okay, well, that hits on the very concern that the state has. The state's not concerned is whether or not you can test this evidence. The state is concerned is whether or not any results you get would be indicative or would be conclusive as to whether or the effects of what the results would be. And so I am very concerned, and I want you to specifically answer in regards to if you would be testing whether or not you can say that that definitely came from the commission of the crime, as opposed to sometime before, or as opposed to sometime after. Your DNA testing answer that.
It certainly could. I mean, we could determine from using the tampon as an example, whether or not that if we get a profile from sperm, whether or not that was from a known consensual partner or not.
What if that known consensual partner is not in CODIS?
Then I would think that unless that person is deceased, we could get a contemporary specimen from that person.
Who would that be?
I don't know.
Unless we have,
That's what case history determines.
correct. And if she didn't tell anybody she had consensual sex prior to being murdered, and she's murdered, we wouldn't know, would we?
Well, Mr. Jones, certainly in every case, there is a history, and we can use the facts that we know to compare to the evidence that we've uncovered. And we may or may not be able to associate a profile to a known person. We may or may not get a hit to that person in CODIS, and then we go from there. That's all I can do.
That's exactly what I'm trying to establish. You would determine the presence of DNA, but you would not conclusively determine where that DNA, when that DNA was placed on whatever item you happened to be examining. Right? Because
That's possible, yes.
Ms. Potkin kept asking you about determining assailant DNA. And can you determine assailant DNA? And would you determine assailant DNA? And the fact of the matter is you discover and identify DNA, but you don't discover and determine whether or not that DNA is from the killer, the assailant, or from anybody else. Is that what you say?
Objection, he's mischaracterizing the questions that were posed to Mr. Keel on direct. The ability to detect assailant DNA is a fact. It's whether or not Mr. Keel's the one making that determination, but he testified about the ability of DNA to recover assailant DNA.
I think this is an expert in DNA. He can make a determination what DNA, if any, is on this tampon. I think you're asking things kind of, if I'm understanding, beyond the scope of this witness's expertise.
Just clarifying for the record,
Well,
what exactly he would test, if he tested and he got results, what his results would indicate. Whether
right,
that's the assailant or whether or not it's DNA that belongs to whatever this profile is. And it's up to the lawyers and everyone to examine the case to determine if it's the assailant's DNA or not.
correct,
Okay.
correct. I agree with you.
And then regarding the cross-contamination, Dr. Keel, I
Mr.
believe,
Keel,
I'm sorry.
just Mr. Keel.
Mr. Keel, you testified in regards to cross-examination that you, cross-contamination would not be a concern for you.
I'm not sure what you mean by cross-contamination.
When I say and use the term cross-contamination, I am using the term in regards to my concern that someone is on any item that they're testing that was not placed on that item during the commission of the crime. When I say cross-contamination, I'm talking about DNA that was put on the item that you're testing before the crime was committed or after the crime committed, the evidence.
Okay, I understand.
Cross-contamination, and I believe that Ms. Pocken used that exact term or mentioned at least contamination. My question is, did you say that contamination, cross-contamination would be a concern for you?
No, it would not.
All right. You mentioned that your lab was certified by the quality assurance standards?
We're accredited by ANAB, which means we adhere to the quality assurance standards, yes.
And do those quality assurance standards, do they address contamination or cross-contamination?
Yes.
How so?
Typically, contamination refers to an unexpected result. And if you get an unexpected result, for example, if I get my biology in the sample during the course of processing it, that is contamination. If it is, as you used the expression earlier, cross-contaminated with another specimen that's being processed at the same time or in the same batch, then that is unexpected contamination, and that can be identified and dealt with in a systematic way in the laboratory. As opposed to biology that may or may not have been present on an item when it's collected and before it gets to the laboratory, that, you know, we can't address that.
And
The result will speak for itself.
I'm sorry?
The result will speak for itself in that regard. We'll either be able to make some sense out of the data or we won't.
And are you saying you make sense out of the data if you've got a positive DNA hit, but it did not match any known samples anywhere in CODIS or any of the other databases that you testified about?
I have many such cases like that, and there's no dispute that that's assailant biology, but nevertheless, it's unidentified assailant biology.
How do you know it's assailant biology if you don't know who it belongs to?
Because the circumstances of the crime dictate that it's assailant biology.
But it would not account for after election contamination, correct?
Your hypotheticals just aren't realistic, Mr. Jones.
Why
I don't
is
know
that?
what else to say.
Are you saying that evidence doesn't get contaminated after it's collected?
No, I'm not saying that at all. But if it does, we can deal with it.
You know whether or not the prosecutor in the case can use the murder weapon not to exhibit closing argument.
I'm sorry, I got about every other word of that. I think you said, did the prosecutor use or handle the knife during his closing argument? Do I know that? I don't know that.
If that happened, if that was done out walls, but that prosecutor on that weapon.
I'm sorry, sir. I get about every other word now.
Go, no, I'm not upset with you. I'm just trying to see if we're going to try again.
Yes. Prosecutor did handle the knife in closing argument, not using gloves. But that prosecutor's touched DNA.
Would that prosecutor's touch DNA and then I lost you?
Be on that knife.
Potentially, yes.
If the jury examined the items of evidence that were introduced in the trial during deliberations, and they did so, their touch DNA be on the items of evidence.
Potentially, yes.
And if they, back in 1988, we weren't wearing COVID masks, if somebody sneezed or coughed, or if they were testifying, had spittle come out of their mouth, and that landed on the item that was uncovered and out of the packaging, but that person's DNA stayed on the item.
Yes, that would be more of a concern than the mere.
So the fact that people weren't wearing masks would be a concern regarding contamination.
It could increase the potential for contamination, certainly, but within the context of the knife, let's say, it depends upon the sample result as to whether or not we would even see a measurable. Let's just assume that half the jury handled it. Depending upon the sample that we take from the knife, if it's male blood and it's not the male child blood, then that blood is going to overwhelm any casual biology that's deposited on there through mere handling it, by a juror. So we can sort that sort of thing out. Now, if it comes down to all we're seeing in a sample from the knife is primarily victim blood, and then there's some low-level alleles, we may not be able to make any sense out of those because they might be coming from an assailant, they might be coming from a juror. That your point is valid in that regard, but otherwise it's not.
So you're saying it's valid, contamination is a valid concern only if you have low-level alleles in your finding?
No, I'm saying we can deal with the potential for contamination based on the data itself.
And when you say we can deal with that, if a drawer did touch it, and let's say the knife, or did touch the glasses, or did handle something else that you test, and you recover that drawer DNA. I'm not talking about alleles, I'm talking about their touch DNA, you get a known DNA profile. And that drawer is not in CODIS. Only way for us to deal with that, as you've been testifying about, would be to have to compel that drawer to give a DNA sample, as well as every other drawer to give a DNA sample to exclude or include drawers as potential contributor.
Well, I lost most of your question. I think I understand your point, and the point that you're making is so far-fetched that it's not credible.
So contamination of items that have been tagged as evidence is incredible, couldn't happen, it's far-fetched.
In the argument and the hypothetical that you're making, yes. In my opinion, yes.
Ms. Potkin? Any redirect?
All right. Just very briefly, Mr. Jones just asked you about the prosecutor, Tom Henderson, or other people, touching evidence. If there is a claim that a certain person, like the prosecutor, touched the evidence, it's possible to obtain a reference sample from that item, from that person, and exclude them as a potential source, correct?
That's certainly one way of approaching it, yes.
For the purposes of the inquiry that we're here today, really, I asked you about a lot of the testing results that would be, most favorable to Mr. Payne's innocence claim, in the sense of what is the potential of DNA testing to identify assailant DNA, and for that determination to be made through matching the DNA to a known person who might have, through CODIS, who might have committed a similar crime. And the mere fact that the evidence could have been contaminated, does any of that undermine the ability of DNA testing to now identify a profile from the crime scene evidence that can be searched in CODIS and potentially match somebody who committed a similar crime?
No, we will either get a profile that's useful or we won't.
Thank you. Nothing further for Mr. Keel.
Anything else, Mr. Jones?
Just one minute question, Your Honor.
If you'd come back around here, please.
Mr. Keel, regarding testing fingernails that you testified about, fingernail scrapings or fingernail evidence.
Yes.
Was it possible in 2006 to test fingernail scrapings or fingernail evidence for DNA?
Was it possible to have tested the fingernail evidence in this case, DNA, in 2006? Was that your question?
Yes.
Yes.
So I have.
All right, thank you very much, Mr. Keel. You're excused.
Thank you.
Thank you.
Thank you, Mr. Keel.
Thank you.
Any further proof?
Looking for a leave button. Oh, there it is.
No further witnesses.
Okay, thank you. All right, Mr. Jones?
Yeah, I do have a few.
Okay.
First, I guess I'd like to call Dr. Pagura.
You solemnly swear or affirm, tell the truth, the whole truth, and that's what the truth so help you God. Okay, sit here, please.
you state your name and spell your name for the court reporter?
Dr. Benjamin Figura, Benjamin. Last name is Figura, F as in Frank, Igura.
And where are you employed and what are your duties?
I'm the director and forensic anthropologist at the West Tennessee Regional Forensic Center. I wear kind of two hats. I do all forensic anthropological casework for the agency, and then as the director, I oversee the day-to-day operation.
Okay, how long have you held that position?
4 years.
And did you receive a defense subpoena in this case for your records in regards to your records regarding the Payne homicide, the homicides of Sharice and Lacey Christopher?
Yes.
And did I also subpoena those records?
Yes.
Okay. And did you search to see whether or not you had any existing evidence that exists today, something that could be potentially tested? And did you search for any records that would indicate what, if anything, or where those might be located?
Yes.
All right, tell the court about that.
Starting back during the 80s, the medical examiner's office was managed by the University of Tennessee Health Science Center.
I'm sorry, I do need to interject an objection because Dr. Figura has stated that he's only worked there for 3 years. I don't think he can testify about what happened in the 80s. There at least hasn't been a foundation for that knowledge.
All right, Mr. Jones, response?
In the capacity of your position as director, have you been, I don't know, informed or educated as to the history of the medical examiner's office? And specifically while researching whether or not any evidence from this case is still in existence?
Yes, I was.
Okay, is that what you were about to tell the judge about?
Yes.
All right. Continue.
All right, go ahead.
During the 1980s, the West Tennessee Regional Forensic Center was managed by the University of Tennessee Health Science Center as part of their Department of Pathology. At that time, the Department of Pathology also had a laboratory that was more or less the crime laboratory in Shelby County. Samples from this case and other cases were collected at autopsy and then submitted to that laboratory tested. In early 2000s, that laboratory closed down. This is when the Tennessee Bureau of Investigation Laboratory opened. Prior to their closing, they had reached out to various agencies to collect evidence that was in their possession. Once they closed down, samples that they still had in their possession were transferred over to the basement of 920 Madison Avenue, which is on the campus of University of Tennessee. In the intervening years, attempts were made to transfer that evidence from the custody of the University of Tennessee over to both the medical examiner's office and the Memphis Police Department. Eventually, it was, I don't know the exact date, but sometime in the 6 months or so prior to early 2014, they were all that material was transferred over to the crime scene unit at NPD. In February of 2014, 3 members of the forensic center staff went over to the crime scene unit to collect that evidence. They went through a few different containers, everything that they had there. Anything that still had a legible, identifiable case number to it was collected, logged, and brought back into our office where it currently sits today. The 2 cases in question, they have multiple case numbers associated with them. There's a C87 number, which is just the medical examiner's case number. There's an A87, which is the autopsy case number. And then the laboratory has on their reports, different laboratory case numbers. Looking at all of those different case numbers, as well as the names of the 2 victims, we went through all the log sheets of all of the evidence that was brought into our custody. So nothing on those log sheets corresponds with any of the case numbers or any of the names of victims. Then we went to the physical evidence itself, which is now contained in 2 plastic bins. And we went through looking at every single sample that was in there, and there were no samples matching any of those case numbers in any of that.
So is your,
I'm sorry, when we also looked for in our histology storage room, this is where we store our histological slides that were collected for analysis during the autopsy. And we don't have any histological slides from these cases.
and we say these cases, are you referring to the autopsies of the 2 deceased in this case, Sharice Christopher and Lacey Christopher?
Yes.
Okay. And so is it fair to say, correct me if I'm wrong, that the medical examiner's office does not have in its possession any evidence pertaining to this case, specifically involving the evidence collected from the autopsies of Lacey Christopher and Sharice Christopher?
Correct.
That's good.
Good afternoon, Dr. Kavira.
Oh.
We spoke on the phone yesterday afternoon, is that correct?
Yes.
And you informed me that the only thing that you had to produce was the records which have already been introduced into evidence.
Correct.
In this case. The file. Dr. Kavira, do you perform autopsies?
I do not.
Do you examine any of the evidence collected in autopsies?
Rare.
Do you agree that it's important to keep a chain of custody log of evidence that comes into custody of West Tennessee?
Yes.
Why is it that important?
It shows an unbreakable series of possessions from the time it was collected till the time it was analyzed, and so we know whose hands it's been in, and as long as that's unbroken, then it eliminates any questions of possible contamination.
And when a homicide victim comes into your lab for autopsy, evidence is collected from that victim, correct?
Correct.
Evidence like finger inserts.
Right.
Vaginal swabs.
Yes.
Rectal swabs.
Yes.
Oral swabs.
Yes.
Nasal swabs.
Yes.
Their clothing.
Yes.
All of that evidence is photographed.
Correct.
And those photographs.
Well, I should say, nowadays they're photographed. I don't know what procedures were in 87 as far as photography.
X-rays are taken with the body.
Again, that now there, most cases it is, again, I don't know for those cases that
The court would take judicial notice of the case of state versus working with the X-ray was.
I'm sorry, I didn't understand. I couldn't-
The court can take judicial notice of the case of state versus Hill working the Shelby County case where the X-ray was taken and later disclosed after an execution. I want to go back over your basic knowledge, Dr. Figueroa. It's doctor, right?
Yes.
Who did you talk to get this historical information?
A number of individuals, including this is over the last 4 years since I've been here, because there's been other questions similar to these cases. Sean Lester, who was our former chief investigator, who's worked there well over 10 years, I believe. And then in the, I think Dr. Handorf in the past, not related to this case, but in the past, he was the former both administrator of the Forensic Center as well as working in the Department of Pathology.
The individuals you consulted actually don't have any personal knowledge of what evidence was transferred where. Is that correct?
In regards to this case?
Yes.
No.
And did you say, and maybe I misunderstood you, did you say that the evidence was transferred to the TDI?
in the early 2000s, the TBI established the crime laboratory, and so the laboratory here at university shut down. I don't know if any evidence was transferred up there, but all the evidence that was left at the laboratory here in Memphis was transferred to the University of Tennessee in the pathology storage, and then subsequently transferred to crime scene unit and then back to the Memphis.
And is there documentation of those transfers?
There's documentation of the transfer from the crime scene unit to the medical examiner's office. The laboratory that was part of the Department of Pathology is a separate entity from the medical examiner's office. They were both under the department, but they were separate entities. So the samples were collected and transferred to, or sent to the laboratory, and then within the laboratory, and after that, that's where we wouldn't have any records of those transfers.
So the Department of Pathology might have evidence in this?
So I am also an employee of the University of Tennessee. They also manage the forensic center now. And in approximately 2 years ago, we went over to the Department of Pathology, to their storage area, because they were renovating it and clearing out. We searched through all of that area for anything related to our office. And we did not locate anything related to our office. And it's my understanding that everything that was in there has been exposed.
So what you have is what came to your lab in 2014.
Correct.
And that is what you searched.
Yes.
And you don't know what happened to any of the evidence that existed prior to 2014.
That evidence is all evidence that spans the period. There are some cases from the 70s, 1 or 2, maybe a handful from the 80s. The bulk of everything is from the early 90s up through the early 2000s.
So in 2014, there was evidence from cases from the 70s and the 80s that are still in your custody and control.
Correct.
But in this case, we don't have a single piece of paper to tell us what happened to the fingernail scrapings in this case once they were recovered in autopsy.
No, when they were recovered at autopsy, we have the testing request form that was filled out by, I believe, by Dr. Harris. And that was requesting that the laboratory test those samples.
Excuse me, because you're correct. They went from autopsy to the lab.
Correct.
After the lab, we don't know where they went.
The only indication is on the bottom of that sheet where it has an indication of a discard date, and it says it has a date and then signed off under that date, which I can't interpret that form completely because it's not a form we use now. But I read that to say that those samples could be discarded after that date, which was about 90 days from the date that they were submitted. Or the date, I'm not sure if it was the date they were submitted, the date of both.
So you're saying it's possible that before the trial of this case, physical evidence in the trial of a capital murder case could have been destroyed?
I don't know. That's, to me, I read as it could be, it doesn't mean that they.
And isn't it in fact the law in the state of Tennessee that if somebody is convicted of capital murder, the evidence is supposed to be kept until conclusion?
Should we clarify as to what year she's talking about?
Do you know what year you're talking about?
I think that's been the case since the 80s on, but we'll get you the statute if you want. I think it's all good. Thank you.
Anything else?
No, no.
No. My next witness.
The next number of states exhibit, I'd like to introduce, I believe without objection, the affidavit from Teresa Weston of TBI.
That's exhibit 27. Exhibit 27. So TBI has nothing.
Correct. My next one is Carl Townsend.
And the circle is the right hand, just one photo, Judge.
Do solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God. See if you're friends.
Thank you for waiting all day. Could you state your name and spelling name for the court reporter?
Carl Townsend, CARLTOWSEND,
And where do you work?
criminal court property room supervisor.
How long have you been an employee of the criminal court clerk's office property room?
I've been here 28 years.
28 years. How long have you been a supervisor?
I want to say about 18, 19 years.
You've been asked by me to bring, and I believe subpoena, I don't know, maybe not, to bring the evidence in the case of Pervis Payne, the trial, the evidence that the property room has.
Correct.
Have you brought to court today all of the property in your possession pertaining to the state
Yes, sir.
versus Tyrone Payne? I'm sorry, Pervis Tyrone. Did you also bring with you a bag that had been at issue for a while? It's not an issue today, but a bag of evidence that was at some point in December shown to the defense team along with other Payne evidence.
Yes, sir.
And that bag that you brought with you today that you showed to the defense team, and I don't know, was it you or somebody else in the property room that showed it to them, or both?
I Mr. Steve.
Okay. Was that a mistake?
Yes, sir. Yes, sir.
Okay. So is the property room's position today that that bag that was shown to them doesn't have anything to do with the Payne case?
That's correct.
Okay. Now, I'm not talking about that bag anymore. The other two boxes you brought on this dollar here are those boxes that contain all the evidence that you have in your possession of Shelby County Criminal Court Clerk's property room pertaining to Pervis Tyrone Payne.
Yes, sir.
Okay. This time, Judge, we'd like to move both those boxes into evidence.
Okay. So collective exhibit 28, 2 boxes of evidence.
Now, I'll tell you what, we probably have to do those individually.
Oh, all right.
I'll back up to the one that
Let's make exhibit 28. Right. Exhibit 28.
This first box here is marked on the outside with the word Pervis Payne. Can you tell Mr. Townsend by looking at this box whether or not this box would contain the items of evidence that were introduced in trial or that were not introduced in trial? If you can tell. If you need to look at the other box.
This box here has residue. But I noticed the box is over.
Okay, so the residue that would refer to evidence that was not introduced,
Yes, sir.
that would be exhibit number 28.
Box of evidence not introduced.
Then this other box. I'm not gonna move it so much here, but on the side here, it's got markings. Would that indicate that this was a box containing items of evidence that were introduced at the trial of state versus
Yes,
county?
sir.
Okay. Move that in, Your Honor, as exhibit number 29.
Okay, so exhibit 29, box of trial.
Do you know how many people have handled this evidence since it was collected?
No, sir.
Were you in the office in 1987 or 88?
No, sir.
Okay, so do you know what condition it was in when it came into the property room prior to and after trial? And one of the documents submitted with the petition, declaration of Ben Leonard, the defense investigator, who I believe is the one who examined evidence in December of 2019. He indicated that he follows standard protocol to protect and contamination of the evidence. He purchased a new box of 200 latex gloves, which he did not open until just before the inspection of evidence began. He wore several layers of gloves and re-gloved after examining each item, and at the end of the inspection, the box of 200 gloves was nearly empty. I also placed a fresh piece of brown paper across the table where the evidence was examined. The clerk's office maintains a supply of this paper for this purpose. Do you know, has the clerk's office, since you've been there, always provided gloves and brown paper to put down on tables before evidence is examined?
Yes, sir. Almost, yes, sir.
You did it for this case, but has your office always done that prior to the time you were employed?
I always talk about on exhibits.
Talk about when people come in to look at evidence. Have they always worn gloves back before DNA?
No, sir. Not always. I couldn't.
Well, you weren't here. When was the first year you started in the property?
About 1992 or 93.
So you don't know what happened prior to that, or do you know what happened prior to
No, sir.
that? And have you always provided brown paper for people to look at in 1992?
I couldn't say all of that, but we had it. Yes, sir.
You don't know if it has ever always been used?
I couldn't tell you all of it.
And once it gets checked out for trial, you don't have any idea of how it's handled
No, sir. I
in court? And somebody else takes it out of the box, puts it back in the box on a daily basis when the trial is in session, right?
Yes, sir.
And you don't have a record of how many people have handled
No, sir.
any of this either. I could approach the witness and ask him 3 photographs. Do those 3 photographs indicate, or do they reflect the property room or one of your property rooms where property and evidence is stored recently?
That's correct.
Do they accurately reflect the way property is stored in that room?
Yes, sir.
Is that, and I don't want you to put on the record the specific location, but is that here in this building?
No, sir.
Is that where the defense came and examined the Payne evidence in December 2019, or do you know?
Yes. I don't remember the date, but I remember we had looked at it at Bellevue, and then we brought back, then they had looked at it on the 4th floor.
Okay. And regarding, you said 4th floor, that's not where you are today, right?
No, sir, we were 12th.
How many times has the property room moved? Let me ask you this. How many places since you've been an employee have there been that the Shelby County criminal court property room stores evidence, whether it's here in this building or else? How many places?
I want to say 150.
Okay, that, I don't want you to give specific address. but
Oh, okay.
potential security. You describe it general,
four different places.
4 different places, okay. And is it common or not common for evidence, especially evidence that has been tried, to be moved around in any combination of those 4 places?
Yes, sir.
And is it fair to say that every single item of evidence you have in your room today has been moved, at least since y'all moved off the 4th floor to the 11th?
Yes, sir. Yes, sir.
I'm sorry. Can you guarantee that any DNA evidence that is on any item of evidence, either of these 2 boxes, was put there at the crime scene?
But I guarantee you,
Yes.
I wouldn't know. You see.
Yes.
Did you want these photos marked?
I'm sorry, yes, I do. I would like to mark them individually and move into evidence. Thank you.
All right, we've got 3 of them. Okay. All right, why don't we fill in? We've got some open, Ms. Melissa, have you already marked them? Have you already marked, written down numbers? Okay. All right, so, well, I was gonna fill in where we've got 9, 10, and 11 open.
Okay.
We'll do that. All right, so these are photos, exhibit 9 would be photo inside the property room. And then this is a photo of this is a photo of property not admitted in trial. Exhibit 10. And this is a photo of the evidence, box of the evidence admitted in trial. This is exhibit 11. Okay.
Thank you. Hi, Mr. Chairman. I'm Kelly Henry, you know that we've met each other on several occasions, is that correct? And I'm not gonna ask you a whole lot of questions, I just want to clarify a few things, okay? And you're the supervisor,
Yes,
correct? And I keep saying criminal court clerk's property room, am I saying it correctly, is that the
Yes,
name?
ma'am.
Okay, awesome. And you've been there for 28 years,
Yes, ma'am.
that's a long time. Now you were asking questions about, could you say what people do every single time they look at evidence? And you haven't been there every single time people look at evidence, correct? But you do train people who work under you, correct?
Yes, ma'am.
And you were trained by the people who came before you, correct? And the criminal court clerk's property room maintains a roll of brown paper for use for lawyers who have reason to come into the property room and look at cases, evidence in criminal cases, is that correct? And you take your job very seriously,
Yes, ma'am.
and you try to be a good custodian of the evidence. And when we, in this particular case, when we told you Mr. Leonard contacted you and said we want to look at Pervis Payne evidence, we had to get a court order, correct?
Yes, ma'am.
And you weren't going to show us that evidence until we produced the court order, correct?
Let's do it.
And nonetheless, you were able to locate the evidence in less than 24 hours, correct?
Less than 20, I couldn't recall that. Because it took a while for us to find that. That was an old evidence, took us a little while. I can't say it took no 24 hours to find that.
But you found it.
Yes, ma'am.
You got an index of it.
Yes, ma'am.
And inside each of these boxes, there's an index of what's inside the box. Where do you go?
I couldn't, I know one of the boxes, this one right here, if they have a list of what be in the box right here. Exhibits.
And you're referring to, the now producing evidence, states exhibit number 29, and it actually says on the outside exhibit list. contained inside that envelope. When individuals come in, such as us, to review evidence, there is some, is it the practice for someone to be watching them while they're
Yes, that's
reviewing?
correct.
You don't just let them take the evidence and go with it wherever they want. And you provide gloves for their use. And somebody just can't come in off the street.
And have to have a form with receipts.
You're not just gonna let some guy say, hey, I'm kind of interested in that Pervis Payne case, let me look at the evidence. And that's because you take the job of protecting the evidence very seriously. Thank you, Mr. Townsend, that's all I have.
Anything further?
Your Honor, if you can, the court, I'm going to ask whether or not you want me to display that items to you. When I went down to examine it, and I saw how it was in these boxes, I didn't want to touch it. I didn't want to further contribute to the way it is. It is the way it is. I would ask Your Honor to consider it, and for purposes of your ruling, and I don't know, I'm happy if you would prefer for me to pull each item out individually now and show it to you. I didn't want to do that before we're in court because I don't want to be accused of contributing in any way to the condition that it was in. In my opinion, from what I saw, the containers are not all secure. There's items of clothing that are loose in there, and so that's why I did not do it. I'm happy to do it now as part of this hearing if you want, or just leave it to you to.
I can look at it. Thank you.
Final thing, Your Honor, regarding, I'm sorry, do you have any other questions?
Is he excused?
Yes. Sure.
Okay, thank you so much.
Thanks.
The only other thing is I would ask the court to take judicial notice of this, and if not, I would ask legal court to get an affidavit from Mr. Campbell. As I made perfectly clear on the record.
Talking about Judge John Campbell?
Yes.
Oh, okay.
I was not aware that the post-conviction DNA petition that occurred prior to today's petition was in Division 3 from Judge Colton. And it seemed like Your Honor had a question about why that was. My understanding, and I confirmed Mr. Campbell's time, was at a period of time prior to today, the clerk's office randomly assigned post-conviction cases to different courtrooms. It's not the way it's done now. It wasn't back then prior. That's what my understanding Mr. Campbell was saying was why that case was in Division 3, not in this division.
The post-conviction came to Division 1. The post-conviction came to 1. And then I got on the bench in 1. And I'm just saying.
I
understand. I'm not accusing you of anything. I'm just saying the petition for DNA went to 3. Petition for error quorum nobis went to 3. And then there was some various constitutional issues that were raised, came back to 1. That's what I reviewed the history of the case. And when you said Judge Weinman ruled on that, I said, no, this is the first time a petition for DNA analysis has been filed in this court. It was in 3.
The only thing I'm raising is if that is important to the court and Your Honor can't take judicial notice of that prior procedure, that's important. I can garnish proof on that issue. I'll leave it to the
What do you mean
court.
take judicial notice? It happened. I mean, there was a ruling, obviously, in Division 3 that denied the DNA request.
I just didn't know if it bothered the court. You want to know why it was in a different court.
I'm well aware post-convictions used to be assigned crazy. In my opinion, the DNA request should have been made here in front of 1. It wasn't. I didn't even know it happened, frankly, until, anyway.
As long as Your Honor was aware of that practice,
I'm well aware post-convictions used to go everywhere, and then we got that rectified. So.
I don't have any additional.
Okay, so that concludes the proof in the case.
Yes, Your
Okay, so we have closing arguments.
Yes, Your Honor, and Ms. Popkin and Mr. Porter will be
Okay,
addressing that.
All right. Are we ready? You need a minute? Are you ready?
We're ready if you are, Judge. Are we
Go ahead.
good?
Sure.
So I'm going to talk briefly and then turn it over to Mr. Porter. The post-conviction DNA statute directs that the trial court shall order DNA analysis where 4 conditions are met. One, that a reasonable probability exists that the petitioner would not have been prosecuted or convicted if exculpatory DNA had been obtained. 2, that the evidence is still in existence and is in such a condition that DNA can be conducted. 3, that the evidence was never previously subjected to DNA analysis, or it could be subjected to new testing that could resolve an issue that wasn't previously resolved. And finally, that the application for analysis is made for the purpose of demonstrating innocence and not to unreasonably delay the execution of sentence or the administration of justice. I'm just going to address briefly the first prong of the statute that deals with a reasonable probability existing that Mr. Payne would not have been prosecuted or convicted if exculpatory results had been obtained through DNA analysis. And Mr. Jones started off saying that since Mr. Payne applied for DNA testing in 2006, that the law had not changed. But the Tennessee Supreme Court, in the Powers case, stated that they were changing the law with regard to access to post-conviction DNA testing and what that analysis entails. Under the Powers case and another case, State versus Nelson, which we also cited in our briefing, Mr. Payne is clearly entitled to the testing that he seeks. The Powers case makes clear that when considering whether a reasonable probability exists, the court is required to presume that the testing will be favorable. The court is required to presume exculpatory results. And in Powers, the court says, this is a somewhat speculative analysis because we don't know the results of testing before we actually do it. But the court in Powers looked to the court in State versus Peterson, another DNA exoneration, to say that in considering whether or not to grant testing, the court is required to consider whatever the most favorable results that are realistically possible in the case are. And in Powers, the Supreme Court of Tennessee said that courts must consider that the crime scene evidence will be searched in CODIS and could match somebody who was convicted of a similar crime. In this case, so taking that analysis, and again, we raised the Nelson case because that was a case from right here in Shelby County where Nelson was convicted of a sexual assault and a lot of the evidence was lost, and a knife that was used in the sexual assault still existed and had been kept, not even packaged, not packaged like we have in our case, but just loosely in a box. And Mr. Nelson sought testing of the knife for touch DNA testing and initially was denied. And then Powers came out and the case went up on appeal. And the court said he's entitled to the testing because even though the state presented the same contamination arguments that it's presenting here, the courts rejected that argument because they said if the DNA from the handle of the knife, the touch DNA, matches somebody who is convicted of a sexual assault in CODIS, it's beyond the realm of reasonableness to say that that is a result of contamination. And so the court rejected a contamination argument of identical evidence that we're asking for testing here. So, the basis of the state's, really the crux of their opposition here is who knows who could have touched the evidence And I think as Mr. Keel demonstrated, some of those arguments are quite preposterous. Nobody was touching the tampon. If there's blood on the knife, it doesn't come from, somebody at the clerk's office touching the knife. If there are discrete deposits of blood at the scene, common sense would dictate that this comes from the assailant who stabbed the victim 42 times, and during which time she had 42 defensive wounds. She's fighting herself, she's fighting this person off of her and trying to save her life and her children's life. So we're gonna be able to say, as Mr. Keel, we're gonna be able to make sense of this, of the DNA once we get the results. But what Powers and Nelson tell us is that this court is required to consider the real probability. It's the whole basis of the entire CODIS database system, that the crime scene evidence is going to be tested, whether it's the knife, whether it's the washcloth that the perpetrator may have wiped them, used to wipe off, whether it's the tampon or the other items, that this crime scene evidence is going to be tested and a profile developed, and that through CODIS, it matches a known individual. And this is not speculation. We cited to many cases in our brief where exactly this happened. The Douglas Warney case, where he was convicted of a stabbing murder, and years later, drops of blood at the crime scene were tested. Turned out they didn't come from the victim, and they matched somebody in CODIS who was in prison for another identical stabbing murder. And that's the entire basis of the CODIS system. And so there is no question under the controlling case law that now exists under Powers and under Nelson that Mr. Payne is entitled to access this evidence. The state's position that there could be contamination is the equivalent of saying, because we could get no result, he should not get testing. Because it could be inculpatory, he should not get testing. But the Tennessee Supreme Court knew better. The whole point of the post-conviction statute is that people get convicted based on significant evidence, and years later turn out to be completely innocent, and advances in technology can show that by excluding the defendant, excluding Mr. Payne here, and identifying the source of whether it's blood or touch DNA or semen, if in fact a sexual assault did occur, through the database system, or to one of the, known alternate suspects in this case. And so with that, I'll turn it over to Mr. Porter. But under the clear case law, this court is required to consider the most favorable test results that are possible in this case. And the most favorable test results undoubtedly would lead to a reasonable probability that Mr. Payne wouldn't have been convicted. That means a reasonable probability that one juror would have reasonable doubt. And there's just no question that he meets that standard.
Thank you. Mr. Porter.
Good afternoon, Your Honor. I'd like to address 3 issues for the court that all relate to the state's arguments for why Powers should not apply here. The first is the argument that the Powers decision does not supersede the 2006 DNA decision or petition decision, and that the court should be bound by that decision. The second argument is that Mr. Payne has somehow waived the ability to request testing of items that weren't requested in 2006. And the third item is the various arguments related to issue preclusion and claim preclusion that the state raised in their opposition. With regard to the 2006 application, that decision was grounded in the reasoning of the Alley case, which Powers explicitly overruled. The same logic of that Alley case was applied in the prior decision here, where the court was concerned that it was an unknown person's DNA that would be discovered, which would not necessarily prove, or which would not necessarily undermine the decision to prosecute or the decision to convict. But as Ms. Potkin just detailed, the Powers case now requires that this court presume that any potential test would match someone in the CODIS system. So that concern doesn't exist anymore. Powers directly undercuts the reasoning that motivated the court back in 2006. The argument of the state also conflicts with the structure and purpose of the DNA Act. Section 3 of Section 304 explains that or contemplates testing in instances where advancements in DNA technology allow for testing that could not have been done previously or could identify evidence on items that had been previously tested. The result of that is that if Mr. Payne had prevailed in 2006, he would undoubtedly be entitled to retesting today because of the technological advancements that Mr. Keel described for the court earlier. And it simply can't be the case that the fact that Mr. Payne didn't prevail in 2006 should now exclude him from getting testing at this point. The advancements in technology allow evidence that was considered and rejected by the court in 2006 to provide more probative evidence today of Mr. Payne's innocence. There's also the fact that the prior decision did not address the full scope of the evidence we seek to test here. It was focused almost entirely on the clothing and bloodstains on the clothing. And what the state says to that is that this is an instance of waiver, and that because there wasn't a request to have the murder weapon tested in 2006, or because the tampon wasn't requested to be tested in 2006, or the fingernail scrapings, that Mr. Payne can't now seek to have those items tested. The problem with that is that it's exactly opposite to the Tennessee Supreme Court's decision in Griffin v. State, which is at 182 Southwest 3rd, 795. It's a decision from 2006. And if I can quote from that decision, it says that the plain language of section 40-30-303 indicates that a petition may be filed at any time, and no provision in the act provides for waiver by failing to request analysis at a prior proceeding. Now, the state will tell you that that prior proceeding in that case was not a prior DNA petition, and so that this case is somehow distinct. But a waiver petition here doesn't make sense. Not only is it not in the statute, but as I discussed a moment ago, the statute contemplates that new technology will become available that could lead to testing in the future. If there was some sort of waiver provision, you would be requiring any potential or any petitioner to request that all potential evidence, whether they think it has the potential to be probative or not, be submitted for DNA testing, even when technology isn't available. There's simply no waiver procedure. It doesn't make sense in the context of the statute, and Griffin v. State should apply here. Finally, Your Honor, to deal with the issues of collateral estoppel, res judicata, and law of the case. First, taking collateral estoppel. There's no collateral estoppel here because the issue before the court today is different than what was brought before the court in 2006. And that's because of the advancements in DNA technology that Mr. Keel described. The question before the court today is if modern DNA technology can identify evidence that would undermine the decisions to prosecute or convict Mr. Payne. That question is simply a different question than the one before the court in 2006, because the types of technology today, the expanded CODIS database, the genealogical testing that Mr. Keel described, none of it existed back in 2006. While there was DNA testing at that time, and there certainly was a request to deal with the bloodstained clothing, it's simply a different issue than what you're asked to decide today, so collateral estoppel doesn't apply. But even if you disagree on whether or not it was a different issue, there's an intervening change in the law, and the Tennessee courts have consistently recognized that an intervening change in the law here, the Power case, operates as an exception to collateral estoppel. Both collateral estoppel and res judicata also will not apply because they would contravene an overriding public policy or result in manifest injustice. The Powers decision is very clear about what the state of Tennessee meant to do in enacting the DNA Testing Act of 2001, and it was to exonerate the innocent and identify the true perpetrators of crimes. Though by using res judicata or collateral estoppel to deny the petition here, the court would be frustrating the purpose of the DNA Testing Act. Finally, the law of the case doctrine is similar to res judicata, but it's more lenient and discretionary. And for the reasons I just mentioned regarding the intent of the state in passing the 2001 Act, it also should not apply here. Thank you, Your Honor.
Thank you. Mr. Jones?
Yeah, I don't want to argue in to the cost of demeaning the state response. I think the state response addressed everything that is on there. I'm just going to hit the highlights.
And if you could speak up so they can hear you,
Where would you like me to stand while I do this?
I,
I can do it up here.
right in my face.
That was
All
on
right,
before, but-
all right.
Powers does not change the law in regards to this case. It says what it says. We don't need to go through it. Your Honor can read a case. Your Honor can discern the issue in the case, and you cannot, Honor can discern what the holding is in the case just by reading it. It's in the first paragraph. What was at issue is when Powers was not an issue in this case. If Payne in this case had said, in order for Your Honor to determine whether or not the prerequisites of the statute are met, Your Honor needs to consider the effect of running this DNA sample through CODIS. He never made that argument. But the judge did, and the Court of Criminal Appeals affirmed the judge's presumption that DNA testing would be done and that the results would be exculpatory. And you look up what exculpatory means, it means somebody else did it. So the court made that assumption. The court made that presumption in weighing then whether or not that would have an impact on the outcome under 304 and 305. 40, 304, and 305. They've had their day in court on this. And for all the reasons in the state's response, it is barred by collateral estoppel, res judicata, law of the case, and they didn't address Supreme Court rule number 4. The Powers case also did, the previous 2006 DNA request did specifically discuss alternate suspects offered by the defense as for persons to compare this to in light of the court's evaluation of that. So it was the court's analysis in 2006 did presume it would be exculpatory in favor of the defense and did presume or did discuss other suspects in considering whether or not the exculpatory results would have an impact on it. Again, that's all in this case, the opinion in this case from 2006. But there's no new evidence in this case. When it was filed, of course, that was an issue. And we've since learned that that was an error in the proper room and that there is no new evidence in this case. So all of the evidence in those two boxes was present in 2006. The only thing that has changed is the technology to determine whether DNA is present on any one of those items. And I submit that is not something that makes a difference on the case because remember what the court did in 2006. The court presumed there would be exculpatory DNA finding. So the fact that today they've got technology that may find more DNA that they wouldn't have found sometime in the past is irrelevant because the court presumed for purposes of its analysis that it did find exculpatory DNA as a result of whatever DNA technology was used to determine it. So because the court did follow the proper analysis and presuming that exculpatory DNA would be found in 2006, that is involving exactly the same issue as your honors has to decide today. If it were considered otherwise, what would that do to the DNA statute, the purpose of the legislature? Because exactly what is happening here could be done by any defendant, where they could say, well, let me go to the property. Oh, there's 15 items of evidence. In 2006, I'm going to petition the court to test item number 1. 2010, I'm going to petition the court to test item number 3. Well, DNA technology is progressing. We're finding more and more. We're getting more. We're getting better in how it is analyzed because of technology, and they can continually do that, and that would impact factor number 4 under the statute, whether or not the petition is for purposes of demonstrating innocence or for purposes of delay. And I think that is one item they haven't addressed in the argument. And 2, I think that clearly demonstrates that their reading of Powers is not the correct reading of Powers. Powers didn't create new law. Because if Powers did create new law, and they do have a case, a client on death row who they say has DNA testing could establish actual innocence. And yeah, we couldn't do it because we had in 2006, but Powers is new law. Powers was decided in 2011. A positive DNA finding like they allege in their petition means their client walks out of jail. Not that he's transferred from one part of the prison to another part of the prison. Their client walks out of jail if DNA proves he's actually innocent. Why didn't they file it the year Powers was decided? Why didn't they file it the next year? Why didn't they file it the next year? They waited until 4 months and 1 week before the scheduled execution. And there was testimony that the lab that they're proposing could do it in, I don't remember the exact time, I think it was 60 days, 30 to 60 days. Well, that doesn't account for any appeal of that decision. They get results. Then we're still back here arguing about whether or not that does the results, whether or not the issue of contamination, whether or not, whatever the findings are, whether there were alleles that don't make for a certain identified DNA pattern, or an identified DNA pattern that doesn't come back as a coded hit. We're still back here arguing about it. Your Honor's ruling about it, and then that's going to be appealed. So that there's most certainly going to be a delay once we get the DNA results, if that is ordered. So number 4 is clearly not met, and the court has already decided the issue as to whether or not under factor number 1, presuming exculpatory results, whether or not that would have made a difference. And the court analyzed it. I want to be clear, I am not at all asserting that Your Honor is bound by direct appeal opinions which describe the facts. Your Honor must look at the facts of the case, presume favorable results, and make that, if you decide that you're not barred by res judicata, if they haven't already had a bite at the apple, and if they're allowed to continue to file petitions. Your Honor is not bound by what the direct appeal decisions say about the facts, but you're also required to consider the facts. And the facts of this case, I submit, when you consider them in toto, are remarkably strong. They're reflected in the direct appeal opinion, which you're not bound by, but they're clearly reflective of that. And the jury heard the defendant testify. The jury heard the defendant testify. And this is not a case like Powers where the defense was, it couldn't have been me because I wasn't there and I've got an alibi. His own testimony at trial was that he was at the crime scene and he had his hand on the knife in Pervis Christopher's throat and he pulled it out, that he was there to help. And Your Honor can look at all the evidence and make a determination for yourself whether or not that is a, whether or not that's one that would likely have made an impact on the jury's decision. The state submits it was not, it did not, and it would not. Final things in regards to their argument that they should be allowed to come back, and because technology has advanced, they should be allowed to seek testing of the same evidence as well as other evidence that they did seek testing on at the first petition, when all of it was in existence. To interpret whether or not the legislative intent of the DNA Act would allow for that. I think the rule, one of the rules of the Supreme Court in statutory interpretation is their presumption that when they're looking at the constitutionality of a statute, they, if they can, will interpret it to comply with the Constitution as opposed to giving it an interpretation that would violate the Constitution. And I submit to interpret the Post-Conviction DNA Analysis Act to allow for petitioners under the Post-Conviction DNA Act statute to, in the same case, allow multiple petitions to examine evidence that all existed at the same time of the first one, to allow them to do that multiple times, extending and delaying the execution of sentence would violate the victim's constitutional right to a final conclusion of the matter.
And so I submit that would render an interpretation of the Post-Conviction DNA Act unconstitutional. I think it's constitutional.
Thank you, Mr. Jones.
Judge, just a few comments. It's, the state's take on the Powers case, I'm not going to belabor because it's, the state is arguing interpretation on things that are very clear in their plain language. So I'm not going to belabor Powers or Nelson, but by the very nature, the law changed. Nelson was a case, and again, this is the case where a defendant in Shelby County sought testing of a knife for touch DNA for the purpose of a CODA search and was initially denied in the trial courts. And it was specifically remanded in light with the appellate court saying we are remanding in light of Powers. There is no doubt about it that Powers changed the law. The statute itself has always said that a court needs to presume exculpatory results in determining whether there's a reasonable probability that the petitioner wouldn't have been prosecuted or convicted. What Powers, the word exculpatory has always been in the statute, and the word exculpatory was used in Payne Decision 1. But what Powers did was define what exculpatory means. Powers said, we have to embrace the technology of the DNA databases that we're building up for the very purpose of matching crime scene evidence to convicted offenders, and that this evidence is not only a tool of the government to identify perpetrators, but it is a tool of wrongly convicted people to secure their exoneration by identifying the perpetrator of the crime who really did it. And so Powers says you're entitled to that. So the analysis that was done on what exculpatory results mean, in Payne 1, the court considered what if Mr. Payne wasn't there? Or what if DNA matched, one person or another? But that's not what is before the court today. And that's not what Powers requires this court consider, which is, DNA from the murder weapon, blood at the scene excludes Mr. Payne and matches somebody else who committed a similar crime. And this is not, just speculation. This happens. There are 375 people who have been exonerated. And in about half of those cases, they were exonerated because DNA identified who really committed the crime. And so Powers does change everything. And the state is reading requirements into the statute that simply do not exist. So to go to the prong that says this application can't be made for the purpose of, or must be made for the purpose of demonstrating innocence and not to delay the execution of sentence or administration of justice. The only delay in getting this testing done right now is the state's opposition. The laboratory can do the testing in 45 to 60 days, and we could have results on all of this evidence. It could be tested, it could be searched in CODIS, and we could have answers. So there is there's no need for this court to go outside of the plain language of the statute. Is the purpose of this testing to delay the execution of sentence? And no, the testing can be done and we can have results by the beginning of November. So the state is trying to read a due diligence requirement into the statute that doesn't exist. This statute doesn't say you must apply for testing as soon as the technology becomes available. It doesn't have that requirement, which would be very prohibitive, and it doesn't have it for a good reason, because this is a statute, when you look at the legislative history, which is discussed extensively in Powers, that is designed for people like Mr. Payne who are claiming innocence and for whom DNA testing can prove it. Now, the state's notion that the only people who could be innocent or who could be proven innocent through DNA testing are, cases like that involve stranger rape is preposterous. It's just contrary to the real life experiences. And I think that's the reaction you saw from Mr. Keel, because his laboratory is doing testing. A man named Aguirre Clemente, we talked about the case in our briefing, walked off death row recently in a case where, just like Mr. Payne, he came to his neighbor's house, and there was a woman and her adult daughter had been stabbed to death, and he picked up the murder weapon, and he did very similar things and left the scene because he didn't want to be implicated. And then he ended up being convicted, and part of his conviction rested on the fact that he had blood on him and his DNA, biology was at the scene. But nonetheless, DNA testing was performed. He was granted post-conviction DNA testing in Florida under Florida's DNA testing statute, and DNA matched blood drops at the crime scene to the victim's own granddaughter, who subsequently had made inculpatory remarks. And Clemente Geary is off death row today. And Robert Dubois, the other case that Mr. Keel started to talk about, where they recently did testing in Florida, and last week a man originally sentenced to death for homicide was cleared by DNA testing. He had applied for DNA testing in 2006 and 2007 and was denied, and the evidence was supposedly not there. And then it was found a couple weeks ago, and in a matter of a couple weeks, that slide.
Ms. Patkin, thank you.
Yeah.
I got it. Thank you. Can you wrap it up?
I'm
Your passion.
I am done, Judge. I will just ask my co-counsel, Mr. Porter or Ms. Henry, if there's anything else you would like to add before I conclude, or I will conclude. And if there's anything else anyone wants to add, other than that, to say, Judge, thank you very much for conducting this hearing with us calling in and being able to present the testimony of Mr. Keel, who really wouldn't, be able to travel from California. And so we appreciate putting up with the technology today to make this happen so that, we could participate and present that testimony to the court.
Is there anything anybody else wanted to say from the petitioner side? You really have covered it very well. I appreciate all of your efforts in this case. You've done a fantastic job. I appreciate Mr. Jones's work in this case. It really is great to have good lawyers on both sides. It makes my job so much easier. So I thank all of you. I will have a ruling very shortly in this matter, okay? I'm going to take it under advisement until September 16, and I will have a written ruling, okay? Thank you very much, all of you. All right. Thank you. Okay.
Yeah.
All right, over now. Did Mr. Ford bring? Ms. Carmen's still here. I'm going to